1 to 6.
Item 2, my lord. On behalf of Mr. Umesh Deora, please not well. Let it come next week, my lord.
All right. You will do it.
Well, sir.
There is a request made from Mr. U.C. Behra and Council appealing to the petitioner, let the matter be listed on 12th September 2023. For the next.
Page number 2.
Item number 4, my lord. Item number 4, my lord.
The request made from Mr. P.K. Rath. Mr. Rath is there in this matter.
Senior counsel, Mr.
And senior counsel. Let the matter be listed on 12th September. Next.
Page number 2, item number 7 to 17. Page number 3, item 18 to 24.
Item 22. I have lodged a caveat.
All right.
A copy we served, my lord, matter be taken up on Tuesday.
It cannot be taken up on Tuesday. Who is appearing for the Mr. Das? Who is appearing for this? Item 22.
Yes, Mr. Kuntia.
Mr. Kuntia is appearing.
I'll serve the copy.
Will serve.
So, since Mr. B.S. Tripathi, one learned counsel, appears for the caveat, the counsel for the appellant is requested to supply the memorandum of appeal and copy of the miscellaneous application.
Next week, my lord, may keep it.
Next week is not possible.
Because limitation is there.
Is supplied. All right. Can it be on 29th? First September. Let the matter be listed on 1st September 2023. 1st September.
Yes.
In terms of the above orders, the caveat petition number 141 of 2023 is discharged. Caveat is discharged. Yes.
Page number 4, item 25 to 27.
25 on behalf of Mr. Umesh Deora, let it come next week.
Is there just appealing to the respondent, but the request made from the same order first case, but only he is not the respondent. Pity or opposite party, right? Same day. Just let us see.
In item 29, your lordships.
Just wait.
In item 29, your lordships.
Item 29.
The request made for Mr. P.K. Rath and senior counsel. The matter is listed on 12th of September 2023. It is made absolutely clear that on the next date there shall not be any accommodation for the appellant.
In item 29, your lordships. Kindly be pleased to accommodate 2 weeks to bring the rejoinder on record, my lord.
Oh.
In item 29.
Okay. Item 29, my lord, the second connected method.
Just wait, just wait. Just in other WPCs, corrected matters. There is check up the earlier orders and list on sentences in view of the order first in such. Just take out any order there. No order is passed. Yes.
Page 5, item 28 to 29.
Item 29.
Yes.
You have to take instruction to petitioner. The second connected method may kindly be placed.
Kindly?
Kindly 2 weeks after.
2 weeks after. You are there, you are Mr. P. Das.
Yes, sir.
There is a request from Ms. P. Das and counsel appearing for the petitioner. That the matter be listed on 27 September 2023.
2 cases tagged together, two cases.
Second, WBC. The other matters, India, the other first, same day.
Page 6, item 30 to 32.
Item 30 may kindly be taken up today, please. Item 30 may kindly be taken up. I'll file a status. I've already filed a status report. Only formal updates.
All right, we'll take it.
Okay. Item number, page number 8, item 33 and 34.
Your Lordship, item 34 to be taken up today.
Let us see what happens. 34 mark it.
Page 9, item 35 to 38.
Item 38. Taken up today, not possible, fix out requirement, employee.
All right, then let us see how things. This we could not contemplate, wait there. Yes.
Page 10, item 39. Last time.
I mean, pardon to mention the last. Retapit to retapit to 2022. The involves appointment under the rehabilitation assistance scheme. The state has filed the appeal and the appointment has been stayed. Application was pending since 2014 to 2010. May I taken up? Similar matter has been posted to 30th August.
Just take on 30th August.
Pardon to mention. I filed a PR challenging the action of the opposite party that the opposite parties were carrying out the construction work for a market building in front of the forest gate, your lordship. In spite of the land allotted to the for the market building, they are constructing the market building in front of the forest gate.
You'll take it up Monday.
These are all fresh and
Yes, Mr. Mohanty, why? Because a particular land has been
Is
allotted.
allotted for some particular
Take
purpose.
instruction.
It should
Though
not be-
we have not issued, just informally take instruction on Monday.
Monday it will be listed.
I may,
Just give the name of the parties. What is the name of the parties? No, for Mr. Mohanty. No,
Mr. Mahanti को memo और ये दे दें the detail.
base admission. This is what reliance went to additional fees by. The law is already admitted other cases. The law is taken up. Let it be taken up by the admission. Base admission so that it will be admitted.
when the other matters are coming on,
Also, matter will be passed of the will also fixed.
all of you come on 30th this month.
I may be pardoned, my lord. WA number 160 by 2023. This matter was listed on 22nd August 2023. On that day, the delay was condoned because I have not objected. I have prayed, my lord, matter may be finally heard.
Okay.
And your lordship has adjourned to 24th, my lord. 24th, it is not listed. Today is 25th, it is also not listed.
Just take up this matter on Monday, huh?
I may be pardoned to mention there is a writ appeal by the state government. The contempt application is fixed to Wednesday. It may be listed on Monday.
All right. Make
But
it
it's clear
Tuesday.
in the press submission. Last week I have mentioned it and it was directed to come in this week. So it has not been listed.
Let it be checked. If there is any objection, matter cannot be listed also.
Can I seek Lordship's kind indulgence?
Yes.
Similar writ applications have been posted 28th of August, Your Lordship. It is identical to that. It will be connected to that matter, Your Lordship. I've already mentioned the writ application number, which is going to be listed on 28th of August, Your Lordship. Much obliged.
Big,
28th August as fixed. Yes.
beg your pardon me.
Let at 2 p.m. All right.
Outside.
Mr. This matter, fixed matter at 2 p.m. will sit for some time in 2 p.m.
2 p.m. Your Lordship.
Just.
Your Lord, grateful.
Supplementary list item number 1.
Yes.
This is the tax revision under the Odisha Value Added Tax Act laws.
Hmm.
And the questions of law they have framed is at page 5 of the Lordship's brief. The Lordship would kindly turn to page 5, please. Even though I have Lordship on page 5 minutes.
Yes.
Lordship got page 5 minutes. So even though I have formulated 5 questions of law, I'd be praying your Lordships may at page 6, question number E, notes, may kindly be admitted. And question number E at page 6 reads as follows, my lords. Whether the tribunal is justified in disallowing ITC on the ground of cancellation of registration certificate of the selling dealer, particularly when the transactions were taken place when the registration certificate were in force and the cancellation of the registration certificate has been made with retrospective effect. This question was raised before the tribunal, notes. And if your Lordship would come to page 33 of the tribunal's order, which begins at page 31, annexure 4. The relevant portion is page 33, paragraph 5 notes.
What is that part of the in the AVR?
Sorry.
It is seen that come to the page 2 of the judgment.
Page 2 of the
32.
In the
32.
AVR, it is seen that the reverse ITC on such and such was disallowed.
So far as the AVR, it
There is a factual part of the same dispute.
It's a part of the same dispute.
Okay.
The question of law which remains, my lord, is that I have made purchases from registered dealers when their RC was in force, the registration certificate was in force on the time of purchase. Subsequently, my lord,
Mr. Mishra, it is apparently a very serious thing. Someone registration certificate when was in force, he carried out certain transactions. He says this is an illegal transaction. How can it be?
Your Lordship, as per the provision, Your Lordship, so far as the allowance of ITC, Your Lordship, the seller has to file its return and to pay the tax. What is the intention of the department, Your Lordship? To get its revenue, Your Lordship. So either the seller is to pay or the purchaser is to pay. Here the provision is very clear that the seller, since the tax has been paid at the time of purchase by the purchaser, so the seller has to pay the tax and admit its return, Your Lordship. Admittedly, in this case, the registration has been cancelled, Your Lordship, that's all right, Your Lordship, and in its return, he has not admitted the tax amount.
You just come to the paragraph 5 of page 3.
Paragraph?
Paragraph 5 of the page 3.
Your Lordship.
It's almost in the mid of that part of the order in paragraph 5.
Your Lordship.
The RC of the selling dealer,
Your Lordship,
was cancelled before the appellant dealer effected the purchases for which the appellant dealer was statutorily levied tax and imposed penalty.
Your
Grounds taken on this course by the appellant dealer is not sustainable. Learned JCS is justified that the penalty under section OP is the statutorily mandated irrespective of proof of mens rea. That is no difficult.
That is as regards to penalty.
No, what Mr. Kaur is very categorically submitted that at the relevant point of time,
Your Lordship,
when the transactions took place, RC was very much in force. If the RC is in force, how can this provision have any implication?
Your Lordship, by Your Lordship, may admit this question of law and let me call for the record, Your Lordship. Let me verify the record, Your Lordship.
Tuesday, the matter will come again.
Your Lordship.
Let us see. At the request of Mr. Shanil Mistral and Standing Council, Commercial Tax, GST, let the matter be listed on Tuesday. So on that day, Mr. Mistral shall produce the records on the question of whether at the time of the relevant transaction, which has been shown to be carried out without valid registration certificate, the registration certificate of the petitioner was valid or not. This is the aspect, Mr. Kaur.
Item number 3.
Your Lordship is calling on Tuesday.
Huh?
Your Lordship is calling on Tuesday.
Tuesday.
Your Lordship, I have to call for the record, Your Lordship, 1 week after.
Who is it?
Item number 3.
Mr. Ian Ray. Ian Ryan.
And Mr. N. appears to the petitioner. Yes.
1 week after, Your Lordship.
Item number
I have to
3.
call for the record, Your Lordship, all the records from different places, Your Lordship.
1st September. 1st September is all right.
Your Lordship, some more time,
Oh.
because it is at Moyurbhanj.
Then it will be 5th September. 5th September is all right. We are getting time.
Your Lordship, for the next week, 13th. 13th, Your Lordship. If it is convenient on 13th September, Your Lordship.
30th September.
13th, 1 3.
13, okay.
No courses at least.
No coercive action in the meanwhile will be taken against the.
Your Lordship, it is 2014 next year.
I understand. In the, all these years you have not taken.
So
all
we were
this.
keeping for a short date. You want a longer time?
Yeah.
All right.
Great look.
Item number 3.
And Your Lordship, so
Item
far as the
number-
other question of law,
No,
my
we
Lord
are,
and Senior is not pressing,
Item number 3.
because that is covered.
I have not also observed that presently we are considering that question of law.
That's all.
All right.
Very key only question number E now.
That is why.
The item number 3, my lord, I am appearing for the respondent.
Yes.
I have raised a preliminary objection regarding maintainability of the writ appeal against an order passed by the Lawrence single judge
And
exercising its jurisdiction under Article
on the
227.
day I asked the learned counsel, yes.
Your Lordship, even though the wording in that judgment, in fact, the power exercise is under 227, in accordance to the 2015 judgment of Supreme Court that is passed in Joginder Singh ji, it is the appellate bench's duty to look into the matter if the power exercise is under Article 226.
That is clearly stated in the judgment that we are exercising the power under Article 227.
Yes.
And learned counsel, I am telling you, withdraw this appeal. Approach the Supreme Court.
But Your Lordship, the writ petition that was preferred for this honorable court's single.
The problem is that I do not understand. There is a practice in this court generally written under Article 226/227 when both the jurisdiction is quite a distinctive jurisdiction.
But in this case, Your Lordship, it can be stated that partly 226 and partly.
No, when the
227
court
is
spells out that it is, I am exercising jurisdiction under Article 227, means that he has not exercised jurisdiction under Article 226.
Your Lordship, but this judgment clearly empowers the court to
Place
look
the
into-
judgment, we'll analyze. We are requesting you withdraw and go to the Supreme Court. There is no difficulty, but if you insist, I will pass an order on merit.
Yes,
All right. Merit means this is only on the question of maintainability. What is your judgment?
this, Your Lordship, 2015, volume 9, SCC, page 1, Your Lordship.
And from the facts also, you have to satisfy that it is actually
Yes.
226 instead of 227.
Yes, Your Lordship.
Your lordship will kindly see paragraph 20, my lord,
Of the judgment.
of the judgment, my lord, paragraph 19. Your lordship, it will be, my lord, paragraph 19. Page 22, paragraph 19.
Thank you. You are referring to paragraph?
Paragraph 19, my lord, the question was framed. Paragraph 20 is the answer, my lord.
You are referring to which judgment?
The Joginder Singh, my lord.
Oh, no. Come to the judgment of the judgment is challenged. That paragraph where it has been.
My lord.
Paragraph
Yes, yes.
6. Paragraph 6.
Last, what one paragraph?
is clearly exercised under 226,
Ma'am.
227, sorry. All right. Paragraph 6 of the judgment, yes. And you are referring to paragraph of Joginder's,
Joginder Singh, my lord.
paragraph 19.
Paragraph 19, the question was framed. The answer is paragraph 20, my lord. Relying on the judgment of the earlier judgment of the Apex Court 1986 Supreme Court, if your lordship will permit me, I will place that.
No, it's already, I have read it.
My lord.
Yes.
Lordship, if I may begin.
My lord,
No.
here, my lord, this
You
court,
read, this is paragraph 18 and 19.
my lord.
Hmm.
The Honorable Apex Court has held where the prayer is to issue rule nisi, and it is a prayer to constitute as Article 226, then my lord, writ appeal is maintainable. But here, my lord, your lordship will look into the prayer and the fact of the case. Prima facie, my lord, it is a case under section under Article 227.
All right. We'll look into this. Yes, Mr. Bhuya.
Lordship, the order that was challenged in the writ petition arises out of the OGP Act, Orissa Gram Panchayat Act. Under that act, even though the adjudicating authority is a civil judge junior division, your lordship, but the real question is, if he is exercising his power as a civil court or as an election tribunal.
Yes.
Election tribunals, your lordship, are amenable under Article 226. And as per Joginder Singh ji, your lordship, once power is exercised under 226, later patent appeals are maintainable. Hence, in this case, the first thing that should be looked at is the power exercised by the civil judge junior division is a power exercised as a civil court or as an election tribunal. Time and again, your lordship, this honorable court, so also other courts across the country refer to these courts as election tribunals, your lordship, not as civil courts. That is the first point that I want to raise. Once it is an election tribunal, your lordship, even though headed by a judicial officer who is also exercising his powers as a civil judge, but in this case, your lordship, my submission subject to your acceptance, he is exercising a power as a tribunal, your lordship, not only as a civil court. If that is this submission of mine is acceptable by your lordship, then there are some powers which he is utilizing as a tribunal. Yes, this court can look into those powers by exercising the power under 226, partly even. And Joginder Singh ji clearly stated that even if there is part application of 226 and 227.
Show us that there was a part application of 226. Application must be under 226. When we are determining the jurisdiction, we cannot go into the merit of the case. What we need to see on the face of the case, that whether that jurisdiction can be attracted or not. Yes, issue was very simple. Your application for condonation of delay was not accepted by the election tribunal. It was dismissed. So you question that merit. So how this can be done in 226? Tell me also, and how it. And Lana Singhal just says the petition is maintainable only under Article 227.
Yes, Your Lordship. But Your Lordship, under Article 227, when this honorable court is exercising the power of supervisory power, Your Lordship, it is clearly mentioned by the Supreme Court, Your Lordship. In case the direction is being issued purely to a civil court, it will come under 227. bereft of the fact that even the single judge also writes that the order is under 226. But if the direction is given to 220, if the direction is given to a civil court, it is under 227 and this bench has the power to look into it. Similarly, Your Lordship, even though
You refer the judgment also.
Lordship,
This is not the solitary judgment that you are relying. In this judgment, there is that case also relied on this Chovinath case of 2000.
Radheshyam versus Chovinath. But Your Lordship, in Radheshyam.
And there only the distinction has been elaborately made. What will come under section, and this Joginder has actually approved that judgment.
Yes. Joginder, Your Lordship, has approved some parts of Radheshyam versus Chovinath, Your Lordship. Radheshyam versus Chovinath dealt with the.
And I find it has been omnibus approval by the Joginder. You are making a distinction.
Yes, Your Lordship, because as per my.
No, whether in Joginder any distinction has been made.
No, Your Lordship, no distinction.
That you don't show that have made a distinction. It is distinguishable, you can submit that. We understand that submission, but you do not say that distinction has been made in this Joginder's case. It has not been done. It is a blanket approval of the Radheshyam versus Chovinath's case.
Yes, Your Lordship.
No, your first point that election tribunal is not a civil court, do you have supported by any authority?
No, Your Lordship, I don't have the authority right now, but what my point was, in case of Radheshyam versus Chovinath, the Surya Narayan Devi case was considered, Your Lordship.
Considered and declared is not a good law.
Yes, Your Lordship. But in Surya Narayan Devi's case, the main judgment or the main ratio was the apex court was of the view that writ of certiorari, that even in the current situation, it cannot be distinguished if a court is exercising its writ of certiorari if it is under 226 or 227. But in Radheshyam, the distinction was made.
It should be under section article 227.
If it is being made
Civil court's order.
Civil court. Yes, Your Lord.
Did you bring this? Have you brought this judgment of Radheshyam?
Yes, Your Lord. I brought this judgment.
Yes. Read. I think it is in the 4 or 5 paragraphs before its end. This distinction has been made.
Yes, Your Lord. Mark copy has been exchanged. Para 25. In para 25 and 26 and 27, Your Lordship, they clearly made that distinction in Radheshyam versus Chovinath.
Exactly.
With regards to what has been going on in English law, what is the current scenario in India, and how Surya Devi Rai is wrong, Your Lordship. That was considered in para 25, 26 and 27.
That in para this 29.2, this Radheshyam,
Yes, Your Lordship.
is clearly spells out the jurisdiction under Article 227 is distinct from the jurisdiction under Article 226.
Your Lordship. Here, para 27 is the part where it is.
Now just see what is the court problem. You do not know. It is the touching the elephant. And that should not be the approach of a counsel who is drafting a case. Because you are to also invoke the jurisdiction for placing your pleadings or amendments whatsoever. You are just saying this Article 226/227 of the Constitution of India.
That is because the election dispute, Your Lordship, is a special case where
I understand. This is a very unique point. I appreciate that point. You're absolutely right when it's purely an order from the tribunal. Just we do in the industrial tribunal, we are perennially interfering with the order under Article 226.
Yes, sir.
Right? But the Radheshyam has created some problem. Do you have the copy of the judgment that I can find out also?
Yes, Your Lordship. I have the copy of the.
This is a para 28, 27, 28, and 29 of Radhesham's case. You just please come.
May I please para
Yes.
para 27.
Yes, para 27.
Thus, we are of the view that judicial orders of civil courts are not amenable to a writ of certiorari under Article 226.
Yes.
We are also in agreement with the view of the referring bench that a writ of mandamus does not lie against a private person not discharging any public duty.
Yes.
Scope of Article 227 is different from Article 226.
Yes.
Then para 28. We also deal with the submission made on behalf of the respondent that the view in Surya Dev Rai stands approved by larger benches in such and such cases.
Yes.
And on that ground, correctness of the said view cannot be gone into by this bench. In Sahil, though reference has been made to Surya Dev Rai, the same is only for the purpose of scope of power under Article 227,
Yes.
as is clear from para 3 of the said judgment. There is no discussion on the issue of maintainability of a petition under Article 226. In Mahendra Sari Emporium, reference to Surya Dev Rai is made in para 9 of the judgment only for the proposition that no subordinate legislation can whittle down the jurisdiction conferred by the Constitution. Similarly, in Salem Bar Advocate Association in para 40, the reference to Surya Dev Rai is for the same purpose. We are thus unable to accept the submission of the learned counsel. In 29, the Apex Court gave a gist of the conclusion that was made in the judgment.
No, that is 226 question is there.
Yes, sir.
Then 29.2.
Jurisdiction under 227 is distinct from the jurisdiction under 226.
All right. All right. Now come to your memorandum of appeal. Whether have you challenged that finding of the learned single judge that he has wrongly deduced that this is a case under Article 227 or not? If that is not the ground in your appeal, obviously you are coming like a blind person. Show us. That where is that ground?
That ground, your lordship,
Because
has not been reached.
so that you are not challenging that finding.
But your
No, I am referring
It's a
to
point
I am
of
referring
order.
to Order 41, Rule 3. Unless you raise the ground, you cannot argue that ground in appeal.
But your lordship, a point of law can be raised at any point of
No, but it is a finding of fact. On the analysis of the fact, he says, yes, the writ is maintainable under Article 227. This is a finding. This is not a pure question of law.
It may be excused, your lordship,
Always the
226
jurisdiction is created by the statute, right?
Yes, sir.
Whether the jurisdiction is amenable in a particular circumstances or not, that becomes a mixed question of fact and law.
But your lordship, my submission, subject to your
Unless you
lordship's
challenge that finding, we perhaps cannot invoke this writ appellate jurisdiction.
But your lordship, the jurisdiction or the power being exercised, that finding, your lordship, is a pure question of law.
No,
Yes, your lordship.
we completely disagree.
Because your lordship, the move question
Just
is.
see paragraph 6 of the judgment.
Yes, yes. May I please the-
Yes, yes.
For the second provision to section 31(1) of the OGP Act, there is power vested with the Civil Judge Junior Division being the election tribunal to condone delay, provided it finds sufficient cause existed there for failure to present the petition in time. There has been assessment by the Civil Judge Junior Division, though Annexure 3, through Annexure 3, finding sufficient cause existed in bringing the application subsequent to time stipulation. It is immaterial whether there is a delay of 51 days or 48 days. This is a question. This is
No, this is a factual matter.
factual matter.
Whether the decision.
Which has been raised in my writ application.
Yes.
Writ appeal. View the reason assigned in delay condonation application. Such order has been passed in exercise of power under section 31 of the OGP Act. In circumstances, if this court finds there is no defect in the impugned order requiring to be interfered with in exercise of power under Article 227 of the Constitution of India. Here, your lordship, my submission is that this learned single bench, merely because the excess of the election tribunal is being tried by the.
All right, but you must challenge that finding. That by observing that it is not, there is no defect to exercise the jurisdiction under Article 227, means he has only exercised the jurisdiction under Article 227. Whatever jurisdiction he has exercised, it is only under Article 227. So unless you challenge that finding, this question becomes that whether in an order passed under Article 227, the writ appeal would lie or not.
Here, your lordship, I'll refer to that Jogendra Singh's judgment.
Why don't you take that ground?
Amendment. Your lordship is provided.
That should have been come at the first line. That is, we are indicating so long.
I'll amend the
Amended. Amended. All right.
Much obliged.
Don't be so technical. Let him allow. You get a chance.
And it's an interesting point, let him pursue
And the
that.
only thing, my lord, the only thing I will indicate, my lord. Not only, my lord, the learning single judge has annulled the order of the.
You have a lot of things to argue also after that amendment is allowed.
On merit, you'll argue.
Whether a tribunal has considered the grounds, whether the delay should be condoned or not, whether that can be replaced by a writ court under Article 226, this is a big area you can argue on that. Right? On the fall of hat, we should not exercise our jurisdiction under Article 226. All right. At the request of SSVR,
Yes, sir.
Learned Counsel appealing to the appellant, let the matter be listed on 13th September. Stop. In the meanwhile, the appellant will be at liberty to file the appropriate application in respect to the proposed amendment. MSD Mahapatra, Learned Counsel has appeared for the respondent number 1. All right. No, this already the election case is a defeated candidate.
Item number 5.
Yeah, Mr. Bhuya, take back the judgment. Although who's ever, I don't know. Yes.
Item 5.
Item 5, none is there. Mr. Mohanty,
Yes, my lord.
we dispose of the petition directing you to dispose of the representation dated
Representation annexed 3.
2003.
Annexed 3.
Yes. None appeals for the petitioner. Since this is a public interest litigation, seeking the direction on the opposite party number 2 for evicting the opposite party number 4 from the government land pertaining to plot number 889 and the Khata number 559, measuring 0.9600 acre by removing any obstruction whatsoever. According to the petitioner, the unauthorized occupation by the opposite party number 4 has created obstructions to reach the main road, as the said plot was being used as the common passage earlier. Stop. It appears from the record that the similar demand was placed before the collector Candrapara by the said representation, by the representation dated 2/1/2023. Huh?
133.
All right. Annexure 3 to this petition. That apart, it has been asserted in the petition that at the instance of the petitioner, subdivisional magistrate was sub-collector of Candrapara was approached for taking action under section 133 of the Code of Criminal Procedure for the said obstruction created by the opposite party number 4. According to the petitioner, no action whatsoever was taken. So, in such circumstances, we direct the sub-collector Candrapara to make an inquiry on the basis of the representation which has been filed to the collector Candrapara on 2/1/2023. Stop. For this purpose, we request Mr. Mohanty Lanet, D.K. Mohanty Lanet, additional government advocate who is appearing for the state opposite parties, to send a copy of the representation dated 2/1/2023, Annexure 3 to the petitions to the sub-collector Candrapara for taking the appropriate action. Before we part with the record, no, stop. We also direct that before any action is taken, the opposite party number 4 shall be noticed and he shall be given an opportunity of raising his defense. Stop. With this observation, this petition stands in our defense. The sub-collector shall complete the exercise in terms of our direction within 3 months from the date when we receive the copy of the order. No, just inquiry on the representation.
And a free copy of the order.
A free copy of this order is supplied to Mr. Mohanty Lanet. Additional government agency for 3. Yes.
Item number 6.
Have you served copy?
We are the affected person, my lord, affected due to the whole project of the Dunga open class project, my lord. That's why, my lord, several representation has been made to the collector to look into our grievance regarding compensation or other benefits are not yet been disposed of by the collector. That was received on the 13/12/2019, my lord. Not yet been disposed of.
Same thing, you direct to inquire.
This is a matter relating to
Land
acquisition of
acquisition.
land acquisition matter. And their prayer is that the lands at the house which have been acquired, they have not been properly evaluated or proper compensation has not.
That we cannot decide in the public interest litigation, but
so there is a
you
statutory remedy.
read the prayer. Prayer is not like that.
The prayer is simple representation, but representation, my lord, may kindly say.
But you go to the appropriate authority.
The statutory remedy is there.
We will observe that the period you have lost in this court will be excluded from the period of limitation.
Yes.
With this observation.
Why have you styled it as a PIL?
Because, my lord, these are all affected persons, my lord, they have not paid.
Mr. B.M. Sarangi, London Council, appearing to the petitioner. In our considered view, after examining the prayer, this petition cannot be treated as a public interest litigation. That apart, the petitioners have the alternative, effective alternative remedy under law, stop. The petitioners have prayed to direct the opposite parties number 2 and 3 to dispose of their representation dated 10/7/2020 and disburse the compensation amount for the house structure that had fallen under the acquired land. Stop. Since the representation dated upon the representation dated 10/7/2020, no action has been taken. The petitioners are at liberty to pursue the appropriate legal action. So we also make it clear the petitioner shall be entitled to discount so far the limitation is concerned for the period they have lost in pursuing this proceeding in this High Court. So accordingly, this petition stands dismissed with subject.
They will approach the authority under the act.
That is a legal action. Subject to the conditions and material. Yes.
Item 7.
Next item also is same. Here in the item 6, there is enhancement or proper award of proper compensation. The next matter is regarding apportionment. Now their claim is that the compensation amount should be paid to a person who is not the original, the landowner. Okay. So that comes with the apportionment provision.
Almost saying, says the prayer portion. The prayer is to make apportionment of the award as made already for the acquisition of land. This cannot be
Page 14 subject.
In a proceeding under Article 226. As the question involves others same. Do the same. No. This is dismissed subject to the condition above. So we are protecting the condition. The representation dated be 13/12. What is check out the prayer? 30/12/2020. 12/8. 12 PM. What called 12 PM is
Item number 9.
1, 2, 3, 4, 5, 6, 7 defects. Filing application with defects.
none appears. It appears from the registrar's note, there are several defects. So, the matter they listed on 13th of September 2023. Meanwhile, the defects in this petition shall be removed. No further recommendation will be made. Who is appearing in this matter? Mr. P.K. Modari, National Government Advocate. Oh, Mr. Mahanti.
Yes, ma'am.
Mr. D.K. Mohanty, National Government Advocate.
Copy has not been solved.
Defect number 6 is
Stop. Yes, no copy of the petition has been solved. Under Order 27 of the CTC. Mr. D.K. Mohanty, National Government Advocate has submitted that he is totally unaware of the fact of the case. Next.
Item 10.
May I please, my lord? My lord, here the leasehold lands has been transferred and registered in favor of the third parties. My lord, kindly have a glance to annexure 9, my lord. Annexure 9, running page number 92, the relevant page is 93, my lord. That is the Registration Odisha Amendment Act 2013, my lord. Here, my lord, that I am reading the amendment 22A, my lord. The registering officer shall refuse to register one is belonging to the state government.
What is the rule 8 of the PIL rules of this High Court?
Pardon, my lord?
You have not filed any representation?
Yes, my lord, my representation is pending at my lord, 10, my lord. That is addressed to the GA department, that may kindly complete, I pay my lord, that may.
It's a notice. That is why they said no representation. Mr. Mohanty, the registry has made an objection that no representation has been filed. So the rule 10 of the PIL rules of this High Court
Has
is
not
not
been
complied
complied.
with. But notice and representation, hardly there is any deviation. Purpose of representation was the placing the defense before the government so that they can consider the issue first and
Yes.
then. So we are obviating this objection.
There is another defect that some Lakshmidhar Jinnah, you have not made him a party, though he has signed in the Wakalatnama.
All right, this is also not a defect.
That he has to score, I think.
My
No, Wakalatnama is there is a party, huh?
My representation, but the intention is that
I
without
understand.
representation, my lord, mandamus cannot be issued, that's why representation is necessary, my lord. So, my lord, my representation is running page 95. It is pending before the GA department.
Is all the questions relating to the sale date. And according to you, the land relating to those deeds belong to the government.
Yes, my lord, that is leasehold lands, my lord.
And
And my lord, in the registered sale deeds, it is mentioned that it is not leasehold land.
that is why
That is the fraud, my lord. The sub-register should check it.
sub-register cannot change it. The sub-register,
can
now the
check
state has to
that.
file this suits for
These
cancellation
are
under.
all civil litigations. Yesterday, your lordship has passed another order on this.
No, but if this is going on and he's brought it to the notice of the court, it's a serious thing.
This is a fraud, my lord.
Whether it is
Clear fraud.
whether it is
Because, my lord, I want to take.
then your lordship may direct the concerned authority to examine the
I think the
representation.
concerned authority, the Secretary Revenue Department.
My lord, here the land belongs to.
No, the Bhubaneswar city
Bhubaneswar,
land,
it is
so
under
GA
GA department.
My lord, one
GA
thing,
department.
Only in Bhubaneswar, it is GA department.
Okay.
only thing my prayer is that.
They will examine and they will find.
Yes, that your lordship may direct this representation to be examined by the director of estate, additional secretary to government GA department, because he is the authority, not
What is the designation?
additional secretary to government GA and PG department. GA and PG department, director of estate, Odisha, Bhubaneswar.
What is the PG? General Administration?
Public grievance.
Public
General administration and public grievance. And director of estates.
Director of estates.
Odisha, Bhubaneswar. No, not already. All of us.
Heard Mr. Shivshankar Mohanty, Learned Counsel, appearing for the petitioner. Petitioners. This is a writ petition in the nature of public interest litigation, urging this court to direct the opposite parties number 1 and 2 to conduct an inquiry on the quote-unquote fraudulent transactions of leasehold plots comprised in Khata number 489/54, attracting total area of 99.000 decimal of Mauja Patia PS New Capital, Tahsil Bhubaneswar, District Khurda. Stop. It has been also asked that the disciplinary action shall be taken against the opposite party number 3 for registering the leasehold plots, for registering the deeds of transfer in respect of leasehold plots. Stop. Mr. Mohanty, learned counsel, appearing for the petitioner, has drawn our attention to the notice dated 20-26-2023, Annexure 10 to the petitioner, and he has contended that the elaborate details of the sale deeds has been referred in the said notice. So for purpose of reference, we extract the documents under question hereinafter. This, it's page 95. That the 1, 2. No, this is not 1, 2. This not this thing. This you'll find it. This page 96. Thereafter report 1, 2, 7 is there after 98. Exactly report this. Stop.
Page number,
Mr. D.K. Mohanty, page 97, 98. Mr. D.K. Mohanty, learned additional government advocate, is appearing for the opposite parties, state opposite parties, has submitted that if the allegations as made in this petition are found truthful, that then it's a very serious allegation. Stop. At this stage, an inquiry has to be conducted, and for that purpose, the necessary direction may be issued upon the additional secretary to the government of Orissa, GA and PG department, and director.
Director of Estates.
Director of Estates,
Orissa,
Bhubaneswar. Mr. Mohanty, and the counsel for the petitioner did not show any reservation about the suggestion made by the Mr. Mohanty and the additional government of government. In view of that, we direct the additional secretary to the government of Orissa, GA and PG department, Director of Estate, Orissa, Bhubaneswar, to make an inquiry in respect of the allegations made in the notice dated 26-2023.
By giving opportunity of hearing.
No, all right. Annexure 10 to to this petition. It is made further clear that the persons in whose favor those sale deeds have been executed, they shall also be given opportunity of hearing. Stop. If after the inquiry it is found the transactions are all illegal and unauthorized, the government of Orissa shall take appropriate step as in accordance with the law. Stop. A copy of this order be furnished to the council for the parties forthwith.
But Mr. Mohanty, you're sure it has not been converted into freehold?
That is what.
You have taken that government.
That government I have not taken.
You have not also checked up.
That is what I said, that this could not have been done. This is.
Let the inquiry be completed.
Yes.
Close the inquiry.
But if your lordship is fixing a time limit, I only pray that a longer time may be given.
3 months.
3 months from the date of communication of the order.
Within
Yes,
3 months,
that's-
it will be completed within a period of 3 months from the date of receipt of the order, this order.
3 copies.
From the petitioners. If petitioner shall file 1 copy.
Yes.
Item 11. Item 11, may I please?
Yes, Mr. Das.
My limited prayer receive that the present person may receive that praying for a yearly establishment of a new PSC building at Balrampur village, and as well as the posting of doctors may receive.
First
Yeah.
to established means PSC means it includes doctor also.
A public health center may receive. There
Without
is no
doctor,
such.
how a public health center can be established? There is a protocol of the government. How many doctors, how many?
He wants that in his village, a PHC should be first established.
That government consider health department.
These
should
are all
my
government
policy matters. That is why.
policy matters. How can
My lordship, that page number 11. Page number 11, the Tahsildar also give the clearance that that is
Not authority. Sorry, some officer has a tendency to exercise the power which is not vested with them.
the land.
We are
acquisition-
directing to the Secretary Health Department.
Yeah, OP number 2 has also received, and he said that the establishment was in page 99. Also, he has OP number 2, my lordship.
Who is OP number 2?
OP number 2, the director of the
Health Services.
Public Health Service, my lordship.
Page?
Page 99. The Government of Odisha Health and Family Welfare Department, Director of Health Services, my lordship. That he has the Director of Health Services Odisha that received that the building approval and posting of doctors establishment of PSC that was recommended, and it was duly processed. But
So
he has
the
not.
competent authority has
Since
already
you are
taken it.
already it is there. It is pending in the higher level. Like,
And that is. But since
in that
222,
case,
there is
matter
no
must have been processed.
There is no such
Anyway, you not saying that.
You want to see the building is coming up.
building of
That is the problem, yes.
There is no such, even the government, the government department, the revenue department has given the clearance.
Why is that clear?
That in 11, page 11, my lordship, that I have filed the contempt petition, my lordship. In the contempt petition, page 11 para 7, my lordship. That in reply.
There
to
was
the-
earlier writ petition also.
Yeah, earlier that was repentation was pending for, that was my in para 7, that was the content petition I have filed, that was not fulfilled. For that reason, the content petition was filed by the present petitioner, and in content petition, the government replied that the content petition, the deponent respectfully submits that the Tahsildar Balyapal has been moved to a proposal for alienation of land in form number 1A at Balrampur, which is also has been duly complied. An execution of alienation process by the Department of Revenue has been made by the Tahsildar Balyapal. A copy of the said alienation made for the establishment of process of PSC New Balrampur Village Balyapal. That has been replied by the government ministry. That is no such land problem, and that was forwarded to the OP number 2. And it is up to the OP number 2, but the OP since 2022, the OP number 2 has not established the and not posting the doctors, and even the not approval the buildings of the said PSC. In page 13, I have already in my
According to the petitioner, building has not been constructed. How the doctors will be posted? But it is in the process.
my
Alienation proceeding-
work is only in the sections, in the director, in the that was up to the direct OP number 2, but that was I have mentioned in the para page 13, my lordship, also.
Page 13.
Page 13, my lordship. That on 29, 10 to 22, the section officer, my lordship, Director of Health Services, given reply to the petitioner indicating that in that the proposal of establishment of PSC at Balrampur village under block Balasur has been recommended, but regards of a hospital building approval, posting of doctors, that information obtained from the that has not been recommended, that has not been followed. Even there is no such appointment of PSC, no doctors, there is no such PSC at Balrampur village.
My lord,
That
in
was
that case, your
recommended-
lordship may direct me to take instruction.
Even
I will file counter.
You file
To show the status of the, what is the status?
the notice will be sought to the OP number 2. There is no such. OP number 2, manage, they will.
We'll take up the matter. We are issuing this notice presently. Because they let them say what they.
What is the status of the?
So it will come on 13th of September.
13th September.
Your lordship may give me some more.
No.
Last week of September.
No, it is only thing that decision has been taken. There is a two The
I
bottlenecks are there.
understand. I
Number one
understand
is
you.
that the alienation of the land. Number two, you just check out whether the financial accord has been granted
Yes,
for this.
administrative approval and
And if
financial.
not granted, how much time that will require?
Yes.
Just you take
Yes.
this instruction. Other matters, I don't need any affidavit is required.
18th of September.
All right. But Mr. P.C. Das, Land Council, appearing for the petitioner. The petitioner is a public spirited individual and he has filed this public interest litigation urging this court to direct the state to immediately establish a new public health center, PSC, at the village Balrampur under the Baliapal block of district Balasore. Mr. Das Learned Council has referred to the information disclosed under Section 6 of the RTA Act by the section officer, Director of Health Services, Orissa, by his communication dated 29/10/2020. From the said communication, we have noticed the following development as recorded in the said communication. Just a paragraph, page 99, first paragraph of the communication, quote, with reference to the later and subject cited above, comma, it is to intimate that as regard to the CONTC number 1180/2020, order DT stop 2208/2022, comma, it is to intimate that in the newly constituted screening committee meeting held on 14/9/2022 under the chairmanship of the MD NHM, with proposal of establishment of PSC at Balrampur under Baliapala district, whatever the Baliapala block, under district Balasore, has been recommended as per IPHS, all cap 2022 norms and duly intimated to government by this directorate's letter number 2986 dated 6/10/2022. So, Mr. Das Learned Council has further apprised this court that the Tahsildar Balasore has already, Tahsildar will be Balasore, I think.
Tahsildar Baliapal.
Baliapala has already identified the land for the PSC and the process of alienation is continuing.
As per his
his statement already. Therefore, the two parting questions to be answered by the opposite parties. So those questions are: one, whether the financial sanction has been made under by the state,
and any administrative approval has been followed by
the administrative approval, and whether the land has been identified and alienated for the purpose of construction of the said PSC. On those aspects, the opposite parties shall file their counter by the next date. Let the matter be listed on 18th September 2020.
May I pray your lordship?
Mr. D.K. Mohanty.
Only to upload this order today, so that I can send the letter tomorrow.
Okay. Mr. D.K. Mohanty, additional government advocate, has appeared for the state opposite parties a free copy of this order be supplied to Mr. D.K. Mohanty, additional government advocate in the course of the day.
Yes,
Type it first.
So it will be PHC bracket new.
yes, madam. That is.
That's all right. PSC is a new, obviously establishment new.
That was indicated in their orders also PHC
No,
bracket
no,
N.
it's not.
That is community health center. Anyway,
It is
I will
because
take
they have
it.
referred
Whatever
that.
the nature of
They
the,
have also referred PHC N.
All right. Huh?
whatever the nature of the health center may be, I will take instruction. Either it is maybe a PHC or a CHC, community health center. That is
No,
public
they
health.
have taken a decision for PSC only.
Yes. Public health center.
All for a village, there cannot be community health center.
No,
Community health center for a block.
but I can appraise your lordship regarding the current status of the project.
All right, you just stop in the counter affidavit. Any other materials may be placed which may be considered relevant by the state opposite parties. All right.
Item 12. May I please, your lordship. Petitioner being a member of primary or agricultural cooperative society has filed this petition. It is a PIL matter, my lord.
Yes, yes.
The grievance of the petitioner in the village Sinnapalli, a primary cooperative society is started, my lord. OP number 6 is a sarpanch. He registered as a cooperative society in his village Lanjimal. The petitioner moved the deputy cooperative society registrar as well as a collector. Till today, no action has been taken. My lord, my reprehension may kindly be disposed of. Annexure 5 or Annexure
All right.
4.
This is a legitimate demand.
Yeah, lord.
So we are directing these registered cooperative societies
Right.
because his deputies are not doing anything. Third, Mr. A.K. Parida. You are Mr. A.K.
No, my name is B.K. Naik, my lord.
Okay, B.K. Naik, learned counsel, appearing for the petitioner. Petitioner is a public spirited individual. And by filing this public interest litigation, has asked this court to direct the competent authority to cancel the registration of the cooperative society under the name and style of Lanji Primary Agricultural Credit Cooperative Societies Limited and to re-register the said society under the name of Sinnapalli Primary Agricultural Credit Cooperative Societies Limited, having its office at village Sinnapalli. Stop. It has been stated by the petitioner. He has filed one representation.
OP number 2, my lord, and dated 17/4/2023.
To the OP number 2. What is the date of your representation?
My lord, 17/4/2023, my lord.
On 17/4/2024.
Well,
Annexure 3 to the writ petition.
my Annexure 5. Annexure 3 is a deputy cooperative society.
Annexure 5, all right. The said representation has been addressed to the collector, Kalahandi. According to Mr. Naik, no order or decision has been taken on the said representation. At least no such decision has been communicated to the petitioner. Stop. For the change of the nomenclature of a cooperative society, it is paramount that.
My lord, this is a small clarification. The society is called Sinnapalli Primary Agriculture Credit Cooperative Society even today. Its registered office is at Lanji. He seeks that the registered office be transferred to Sinnapalli.
All right. That will be done by the register of the cooperative society.
Your lordship. But actually,
change
this
of the place of business. Only you want the change of the village.
My lord.
Change the name of the village.
OP number 6 is a sarpanch. He is changed his name and registered in his village, man. Lanji, my lord. The petitioner of the Sinnapalli made a reference before the authority. No action till today is taken.
Change the, no, this name was the Lanji Primary Agricultural.
Another village. Another
page
No,
4.
no, just come to the prayer of the petition. They want also the change of the name of the agricultural cooperative society.
My lord, if your lordship sees the pleadings at page 4, page
Which
4,
one? You don't change the name of the society. Only the office of the society you want to change. Just come to your prayer. You say the Lanji to Sinnapalli.
You want to cancel the registration in the original name and fresh registration.
if your lordship sees page 4, second line, the Sinnapalli Primary Agriculture Credit Cooperative Society has been formed by the farmers of the villages, namely Sinnapalli, Lanji, and Mahendrapur. 3 villages have come together and formed a single society.
What is the certificate of the registration of this cooperative society?
Sinnapalli, my lord. We are the representative.
No, what is the name of this society as of now?
My lord, primary agriculture cooperative society Sinnapalli hoba katha Lanji.
Haba katha nahi, kona heichi pacharuchanti.
Lanji.
What is the name?
My lord, Lanji. I am cancelling that one.
Lanji Bali.
That's a change.
The pleadings don't match the prayer. That's why.
That is why.
You see, page 4. It was decided for the society to function at Sinnapalli, but the Sarpanch of Sinnapalli GP registered the said society having its office at Lanji.
Well,
therefore, the name is Sinnapalli.
Where is it?
That second line, your lordship. Within quotations.
Now, the last line also said that only the village name should be changed. Village should be Sinnapalli instead of Lanji.
Look at the prayer.
There is something different. What is the name of the cooperative society?
My lord,
it is Lanji.
Sinnapalli Primary Agriculture
Cooperative prayer, council, come to the prayer.
What is the registration? That is important.
Registration of cooperative society in the name of a Lanji Primary Agriculture Cooperative Society, Cooperative Society Limited, and further registration, register the same in the name of a Sinnapalli Primary Agriculture Cooperative Society Limited.
Do you have any paper of any letterhead of the society in your file? Any letterhead of the society? Just show us any paper.
Annexure 1, page 13. The villager of the Sinnapalli has deposited 5,100 in the primary cooperative society in Sinnapalli, my lord.
This is the name of the bank.
Annexure 2, a meeting was held, my lord, on dated 28 March 2023. 17/4/2023, they have also represent before they have approached the deputy cooperative society register. What is the illegality?
And your lordship may kindly see page 7, paragraph 9.
Your document is there.
Page 7, paragraph 9, the pleading.
Deputy Cooperative Society, OP number 4, has inspected the society.
At Gram Panchayat office, Sinnapalli.
And the farmer and villagers of Sinnapalli raised objection regarding registration of fees.
They have met there and had the meeting there. But agreed by the name. And main
That is
thing
also
they are
not very
stating.
clear. What is the last one you have written?
See paragraph 9.
Your lordship.
I think everything is there at Sinnapalli, but that registration
Is
the
at
name
Lanji.
of Lanji.
There is no decision, even if taken has not been communicated to the position of stuff. It appears from reading of this petition that there is some division of opinion is respect to the name of the cooperative society and its registered place of registered office.
Ground H.
Your Lordship.
Be that as it may, the district collector doesn't have any role in this matter. Therefore, the representation that has been filed before him is of no relevance. If the petitioner is a member of that society, his duty would be to convene of the meeting of the society and to take and to press for taking a resolution in the society in its general body in respect of the change of the either the name of the society or the place of the registered office. Only after such resolution is taken, the registrar of cooperative society or his delegates can make necessary amendment in the memorandum of association, memorandum of the cooperative society or its bylaws. Stop. As such, the no direction at this stage can be issued to any authority to consider the same. The petitioner may follow the process for purpose of the above change as per law. In terms of the above, this petition stands disposed of. You cannot do because you have to take the general body meeting. Whatever you want to do, this is a prerequisite in the law.
Annexure 2, they have some resolution, but it has to be clear and to the point.
The general body meeting, take a resolution and send. Stop. If this has resolution is placed before the registered cooperative societies, he shall take immediate action for the necessary amendment in the registration or any other documents that is maintained for purpose of that cooperative society. Okay.
Item number 13.
Engineer DPI and roads present along with this sketch map. Your Lordship may kindly have a glance. Annexure 9, page 58, the most important paragraph. Annexure 9, page 58, the order of the government. 1, 2, 3, 4, 5th paragraph.
Yes.
And whereas Chief Engineer DPI and roads via his office letter number so and so has intimated that the alignment of the ring road has been finalized as per the original CDP by the Bhubaneswar Development Authority, BDA, for a total length of 65.13 kilometers, including the stretch between Tamando to Paikrapur from CH so and so to so and so kilometers. So this alignment has been prepared by the Bhubaneswar Development Authority since long, and they are only the executing authority. This Chief Engineer DPI and road or the works department, this alignment has been drawn and they have prepared according to the CDP. CDP means City Development Plan of BDA. So that CDP cannot be changed at the behest of a particular party on the ground that a portion of our playground is going to be acquired or taken by, and that is also government land.
We understand. But they are apprehensive of losing the playground, nothing else.
Not the entire playground, a portion. What I
Your Lordship, if I may be placed to permit, Your Lordship, if that road goes on the playground, Your Lordship, that mini stadium loses its nature and character. It is virtually impossible that any sporting activity can be carried on that, Your Lordship. And the other playgrounds which the opposite parties had mentioned on the previous occasion, Kalinga Stadium is at 16 kilometers away from this playground, and another is the Northeastern Railway Stadium, that is again 15 kilometers away. In that whole Tamando area, Your Lordship, this is the only mini stadium, Your Lordship, and that is being taken care by the opposite parties themselves, Your Lordship. So what we are praying is, Your Lordship, we agree that a tender process is being carried out on a stretch of 5 kilometers of the whole road that is there. We are only seeking realignment of hardly 500 meters of the road, Your Lordship.
In that way cannot be done. The entire road, if Your Lordship will allow
Mohanty,
yes, ma'am.
Mr. Mohanty, just allow the chief engineer speak out.
Yes, yes.
Because we are also not the experts
Yes, my lord, yes.
in the drawing up the
No,
roads.
what I submit on his instruction, I discussed with him.
Instruction, I
in the past hour.
understand.
That is why,
Let-
otherwise,
let
I am
him-
also
let him
not a
also
technical
fetch some
person.
questions from us. Sometimes layman's questions also becomes very important
Yes, ma'am.
for the experts.
You answer.
With this road, a particular, to save the playground, it can be just taken a little, the plan can be little bit deviated or not. Because sanction and approval, all these administrative job. And if you can save, why don't you save a playground? There is another question. Whether the government in a position to keep this shape of the playground, the area of the playground by adding from some other government land, adjoining land is possible or not? Have you explored that aspect of the matter? Suppose for road you are taking a part of the land and that makes the playground unusable actually as a playground. She says it's a mini stadium. We do not know whether it is a mini stadium or not and what is the definition
Your
of
Lordship,
mini
there's a
stadium.
map, Your Lordship.
Is it possible? You can just think over because you just in a community there must be some space for play and entertainment. This is a part of thing. Road is definitely very essential thing, but this is not also inessential.
If your lordship will permit me, I will submit a few words.
No, no,
If your
just
lordship
understand.
please.
We understand your limitations also.
That is what I wanted
There
to
is
say.
the first proposition may not be acceptable as such. Have you explored the second proposition? Whether the area of the playground can be shaped. And I find from the road, it is a very little portion of the land. It is about 10,500 square feet area has been taken away.
Your Lordship, once
Only a portion where your clubhouse is there, that
once-
portion has gone.
Your Lordship, once a road, no, Your Lordship, that is, Your Lordship may look
Maybe
into
some
annexure
more
3.
portion will be there.
It's not
because-
virtually possible for the sporting activities to be carried out beside a road, Your
All
Lordship.
right, all right. We are not that much interested about the sporting activities. Just we are seeing that whether this space can be some way can be restored without disturbing the road. Now, state road is not project road. This was the road, ring road. The red line was. State road is already existing road.
Yes.
Your Lordship, I may be permitted to take Your Lordships to annexure 3. The playground doesn't belong to us. We are only custodian, Your Lordship.
You are also not custodian.
Your Lordship,
no,
as per
custodian-
annexure 3, Your Lordship.
No, who has made you the custodian?
Your Lordship may look into annexure 3, Your
All
Lordship.
right, all right. Yes.
Annexure 3, page number 23, Your Lordship.
Yes, yes.
Government.
Yes, it is a government plan.
Yes, Your Lordship. And in page number
How
20,
it shows that you are the custodian.
Your Lordship, in page number 23, out of the 4 stadiums that are there in Bhubaneswar, presently used by Shiv Shakti Club, recorded in the name of government, Your Lordship.
Yes.
So we
So
are
you
the
were-
one,
Because that was
Using that
vacant, you were
space.
using.
Your Lordship, we were only taking care as to the trimming of the club and all those activities.
All right, because you are using that space.
Your Lordship, we are
Custodian is
not.
something different.
Is
Yes,
there an order?
Your Lordship, I understand that, Your Lordship.
Custodian is officially giving you the responsibility of the looking after of the playground.
Your Lordship,
That has not happened.
Your
They are
Lordship,
allowing,
that is
they are
what-
not opposing that you are using that. They have also recorded it. That's all. And for your use, you are making some changes in development for that.
Your Lordship, that is what is my contention, that we
You
are
have to
not
understand
using
the
it for
legal
ourselves.
implications. We're going to make some certain thing that if you record that, that will create a lot of problem for the state. Only thing, just have you seen this? This
Yes, Your Lordship.
JPEG? Have you seen it?
Yes, Your Lordship. We have. We
So,
do have
Mr. Chief Engineer, whether this can be a little bit of government land can be added to that. This part actually they have marked this part is going for the land.
He's saying. It is. there are two options for it. One is realignment of the road, which affects again on both sides of the present alignment, it affects because the other side, the TP scheme BD has already allotted the plots as basing on the this present alignment of CDP. So all those plots will be affected. Number two, this side also the plots will be affected if we go for a little realignment of that portion. Second, as regarding searching up another government land nearby, there is no as such government land for addition of any more space to that land.
If there is no government land, can the vacant private individuals' land is available there?
That can be explored.
That should be explored. And that way, actually, we can meet the problem out. So go for, because it is a development project. So for the ousties is concerned, we not the principle of the government. They should be rehabilitated and compensation be paid. Since it is a playground, even though there is no declaration, but some club has come forward that they are using it. I think playground should be also preserved and it should be kept in its use.
Portion of the playground is affected.
Portion of the playground, not. No. If
Yes,
portion
marked
goes,
it.
suppose there's a track and that gets affected, then it'll be because it has to be 400 meters or something. So if portion of that goes, then there'll be no use. You can't use it as a
Just need
stadium.
to request you just go to that playground and give an alternative proposal.
Yes, sir.
Because we understand that the change of realignment will bring a lot of complex situations. So that we are giving a direction. So you come on 13th of September again with your alternative plan if you can provide for the government. Some officials from the sports department to just make a proper survey whether the core activities of the playground will be affected or not. Only the clubhouse or tent area is affected, that you can make somewhere adjoining thing without changing the alignment, because they are interested to keep the playground
Field area.
and so that its activities as on going on today can be continued in future also.
Like for football and cricket, you need a particular area. If that is reduced, then they can't play. So if that can be
We are
adjusted
fixing
also.
the matter. May I have your good name, sir?
Manoranjan Mishra. May I pray one thing to us? In this case, BDA may be included and notice because that is very important.
Always.
They are the original, because they are the original agency who has made this alignment.
Chief Engineer, within bracket, DPI and Roads, Works Department, Government of Orissa, has appeared in person in terms of our order dated 18th August 2023. We appreciate the way he assisted this court for finding solutions to the present problem. We would request the chief engineer, the same DPI and such Works Department, to take assistance of the technical experts of the sports department and make a survey about two aspects. This one, what is the exact area that is being extracted out for purpose of realignment of the ring road? You call it a ring road stuff. And secondly, to see whether the core area for the sporting activities is affected. Stuff. That apart, we request the chief engineer to have a discussion with the Bhubaneswar Development Authority whether some land from their control or some land can be acquired from the individual vacant plots adjoining the said field to preserve the present status of the field so far its activities are concerned. Stop. They have taken a plan without allotment also. There is a BDA first come. Here says is very correct.
No, that.
All right. Having regard to the nature of the dispute, we would like to add, was the commissioner BDA?
No, secretary, vice, VCBT. Vice Chancellor, Vice Chairman, Bhubaneswar Development Office.
We are also, we add the following as the party respondents. Following entities. One, the Bhubaneswar Development Authority represented by the Vice Chairman, represent the
Vice Chairman, Bhubaneswar Development.
Vice Chairman, Bhubaneswar Development Authority. Can you give the address?
Your Lordship, OP2 is, OP number 2 has been, is the
Planning member you have
yes, Your
made.
Lordship.
So that must be the
Then
address.
it's okay, then it's okay. Then notice may be because Mr. Mahapatra will appear. Notice may be issued.
Yes,
It's okay.
Then we do following.
Then sports department is
Sports
necessary.
department is also a necessary party.
Youth services, what is the exact?
Sports and youth services. No?
Sports and Youth Affairs or Youth
Youth
Services?
affairs.
Services.
The he is the director, I think. Highest authority. The
Director of sports.
Director of
Director of Sports and Youth Affairs, Government of Orissa,
Director of sports.
Bhubaneswar. The notice on the said headed respondent is served through Mr. D.K. Mohanty, an additional government advocate. We would request Ms. B. Mistral and counsel appearing to the petitioner to serve an additional copy of the writ petition on Mr. Mohanty and counsel in the course of the day. Stop. After the survey, a report shall be placed before this court on the next date.
Yes. Well, a free copy may be served on me today so that I can
free-
communicate to others.
Free
All
copy of this order is served on Mr. D.K. Mohanty and additional government advocate in the course of the day. We
Lordship
place our appreciation for the appearance of Mr. Such and such, Chief Engineer such and such, is dispensed.
Lordship is fixing it to 30th
13th of September.
and it will be 18th Monday.
13th of September.
Yes.
All right.
Much obliged. Your Lordship.
Item number 18.
We keep this on the record, Mr. Mohanty.
Yes, my lord, that is.
You want it?
We'll take it back. We'll do it final report, part of these things.
May please, Your Lordship.
Yes,
My lord, discuss toward the delay have occurred in filing the writ appeal, my lord. The filed limitation petition, my lord. Delay.
Have you removed the defects?
Yes, I have removed the defects. I have removed all the defects.
You have
Yes,
removed?
yes, yesterday I have removed all the defects.
All right, but there is no. All right. So first come to the condemnation petition.
Yes, ma'am. And total delay have occurred in filing the writ appeal, my lord. Due to the-
So we condone the delay, Mr.
Yes, my lord, your lordship. I was just verifying there what is the delay.
12 days.
Only 12 days delay, your lordship may condone.
All right. Your good name, sir?
Kalpatar Misra, K. Misra. Kalpatar Misra.
Third Mr. in the I, only one I here. Mr. Kolkata Biswal and counsel appearing for the appellant / applicant. This is an application for condonation of delay. There is a delay of 12 days in filing the intercourt appeal, challenging the order dated 7/9/2020, passed by the Land Single Judge in WPC number 3129 of 2020. Mr. D.K. Mohanty and counsel appearing for the respondent opposite parties, as at the outset submitted, the delay may be condoned. Stop. We also find there is no reason not to condone the delay. Accordingly, the delay stands condoned and this application is allowed and disposed of. Next, the writ appeal in view of the order passed in RA number such and such, the appeal is taken up for consideration. Yes. Why are you challenging that order?
No. The appellant is challenge the order dated.
Last paragraph of the order.
Last para is important. Yes. Last paragraph. Since there is a dispute with regard to agreement which arises out of a contract, the same cannot be adjudicated in the writ itself. As such, the question is raised with regard to annexure 5 dated 31/8/2019, wherein it is stated that item 2 of the agreement coupled with clause 4.8b and c does not include reimbursement of cost of royalty, which is required to be adjudicated in proper forum. Therefore, this court is not inclined to entertain this writ itself, as the same not mentioned. However, liberty is granted to the petition to approach the appropriate forum by filing a suit if he is so advised. If they have objection, the writ petition stand as per law.
If there is no clause in the agreement regarding the royalty,
yes,
how can you come to court under this article 226?
Well, there is a condition in agreement, my lord. The lords, you can see.
Where is your agreement come?
First page of agreement.
Have you given the entire copy of the entire agreement?
No, my lord, only given first page and second page, last page of it.
Show from the first page, there is a clause for the royalty.
That particular clause.
Clause, my lord, item number 2, my lord, at page 64. 64, item 2, my lord. I'm reading, my lord. Exception of any approved type of soil in approved borrow area by mechanical means, loading into and transportation by mechanical means, and unloading the soil with an initial lead of 10 km on properly prepared and scientifically approved surface, including spreading and leveling the earth in 22.5 cm layers to make ready for watering, and compensation with the seed foot rollers and rogers.
Where are you reading? Page 64.
64, page 64, man.
64 of the appeal memo.
What is that? That is some annexure.
This is a schedule of the quantities. Page 63 starts with the schedule of the quantities and
Yes,
then
no, item 2 is the agreement.
Yes.
Item 2 is the agreement. Item 2.
That
Item
is
number 1,
no
item 2,
mention of royalty.
just below.
Excavation of approved, yes.
Yes, ma'am. Exception in approved type of soil in approved borrow area by mechanical means, loading into and transportation by mechanical means, and unloading the soil with an initial lead of 10 km on properly prepared and scientifically approved surface, including spreading and leveling the earth in 22.5 cm layers to make ready for watering and compaction with the seafoot rollers and rogers, but excluding watering and compaction in dams and dikes for all heights, including construction, maintenance, watering, and lighting of house loads and borrow area. It's a complete as directed by the engineer in charge. Measurement of the field to be taken in the finished compacted area under incidents.
so what is there?
How
it is? This is the as per the rules you have to carry the excavated.
Invite your lord's attention to page 70, my lord. That is annexure 7, my lord. Para 6, my lord. In respect of analysis of the agreement, item number 2. What I read, my lord.
Where are you reading?
My lord.
At page what?
Page 70, my lord. Annexure 7.
Saturi.
Instead of page
That paging has been changed subsequently. That is why it is also not changing.
Okay, read what? Internal page you read 1, 2, 3. Which one?
60.
Letter dated 31/8/2019.
31/8/2019.
All right, where?
Yes. Para 6. In respect of analysis of the agreement item 2, the royalty of borrow art at the rate of 35 is due meter has not been included in the analysis of the said item, such as as per the revenue department guidelines, the royalty of art is to be deposited with the revenue department after deducting from the work bills, and the same procedure followed by FSCO and KIP. Hence, the royalty component for the above agreement item that is rupees 36,49,842 is to be included in the agreement with sanction of a revised estimate. The value of revised estimate comes to 7,23,11,786. All other agreement items are remain unaltered in respect of quality and quoted rate.
You go for the arbitration. This is not the case which can be decided in a proceeding under Article 226.
Initially they admitted in the item 2 of the agreement has not been included in analysis. So
this is an analysis. This is not the part of the agreement.
Yes.
And this is not also approved by the state, competent authority of the state. Someone is analyzing, interpreting the part of the clause.
Yes.
Will not help you out. You go for this arbitration. Otherwise, you have no other remedy.
I think there is no arbitration clause. That is why the Honorable Single Judge directed him to go for civil
court. Go there.
Initial this Honorable Court directed the respondent 3 had annexed 2, my lord, at page 57.
To dispose of the
repeats.
And that is done mechanically. That now we are not that phase.
Yes.
We have just crossed one phase. That is the preliminary. This earlier writ petition, this direction was given.
Yes.
We do not find any defect in the order. So, sorry, come with a better case next time. Heard Mr. Senator Das, Land Counsel, appearing for the appellant. Also heard Mr. D.K. Mohanty, Additional Government Advocate, appearing for the respondents. By means of this writ appeal, judgment, the order dated 7/9/2020, passed by the London Single Judge in WPC number 3129 of 2020 has been challenged. London Single Judge, by the said order, has observed as follows. Last paragraph, page 75. Quote, since there is dispute with regard to agreement which arises out of contract, the same cannot be adjudicated in the writ petition. As such, the question is raised with regard to Annex 5 dated 31/8/2019, wherein it is stated that item number 2 of the agreement coupled with clause -4.8 within first bracket small b and within first bracket small c doesn't include reimbursement of cost of royalty, which is required to be adjudicated in proper forum. Therefore, this court is not inclined to entertain this writ petition as the same is not maintainable. However, liberty is granted to the petitioner to approach the appropriate forum by filing a suit if he is so advised. Stop.
Item 19.
No, this just has not. Mr. Mishra, Land Counsel has pointed out to one analysis of the agreement wherein it has been observed by the executive engineer concerned that in respect of analysis of the agreement, Item number 02, the royalty be borrowed for borrowing. For borrowing, sorry. It is borrowing earth.
Yes, borrow earth.
To borrow earth. For borrowing earth at rupees 35.00/COM has not been included in the analysis of this said. What is this part you read? It is not readable, huh? The said item.
Item 7, Annexure 7, my lord. Annexure 7.
Said item.
Paragraph 6, page 70. Ma'am, in respect, yes, ma'am.
Said item. Second line.
In respect of analysis of the agreement, item number 2, the royalty of borrower at the rate of 35 rupees per kilometer has not been.
No, this second line comes straight to the this second line has not been included in the analysis.
In the analysis of the said item,
as per the department guidelines.
Yes, as per the revenue department guidelines.
As per the revenue department guidelines, the royalty of earth is to be deposited with the department after deducting from the work bills, and the same procedure is followed by a FA and CAO, KIP. So hence the royalty component for the above, i.e. rupees 36,49,842 is to be included in the agreement with sanction rate. The value of the revised estimates comes to rupees 7,23,000, sorry, 7 crore 23 lakhs 11,786.00. Stop. All the items, all the other items remained unaltered in respect to the quantity and quoted rate or favor of the kind, information and necessary action. Stop. There is no document to show what happened to that observation made by the executive engineer, whether that proposal has got sanctioned or not. Stop. But it is an admitted position. As per law, the royalty has to be deducted from the bills of the person who excavate and carry the earth for any other purpose, for purpose for which such excavation was carried out. Stop. We do not find that there is any admitted position in this regard. What the executive engineer has observed, it is a mere proposal. As such, the petitioner doesn't have any, the appellant doesn't have any consultative right to to approaching this court seeking direction for reimbursement of the amount that the appellant is liable to pay. Stop. As such, we do not find any there's infirmity in the order of the learned single judge, and accordingly the appeal stands dismissed. Mr. D.K. Mohanty, stop, dismissed. No days to cost. You have so many remedies now.
Yes.
You go and give a notice to the executive engineer to take action on his own proposal. Then from there you build up a new case.
Respondent 3 has admitted there is not.
No, but admitted thing and your right consolidated in the contract is a different issue. Yes. That is what I have observed. All right.
Then shall we approach to civil court?
You can. That is already
given by the honorable single judge. Item number 19.
Approaching civil court.
Engineer giving notice.
Yes. Item 20. Yes.
I am actually for the opposite party number, respondent number 1 and 4.
Yes. Are you prepared? Are you prepared today? You are prepared.
Minus.
Make your submission.
In fact, this is for continuation of delay of 43 days, my lords.
I think you don't oppose it. Continuation of delay, there is a delay of 40. You don't oppose it. Oppose it.
Yes.
We'll file the objection.
Respondent number 1 and 4.
Your ground
Are
for
you going to
opposing.
file any objection?
Orally
Are you going to file any objection? So far, you have not filed.
There is no strong evidence in their.
Say that I will file objection. Let the matter be listed on 27 September 2023. What is good name, sir? The request of Mr. J.P. Tripathi and counsel appearing for the respondent number 1 and 4. Let the matter.
Have you filed wakalatnama?
On 20.
In the meanwhile, those opposite parties. Someone to read opposite party, not to respond. I will pass the audio. May file their objection if any.
I am appearing for opposite party number 3, my lord.
Who is appearing for the petition? The appellant.
I am for the appellant.
Mr. S.K. Mohanty. Here, Mr. S.S. Satyadarshi and
P.K. Mishra, my lord.
PK Mishra.
P.K. Mishra. Mr. Satyadarshi is with you.
Is my associate, my lord.
Mr. Your opposite and Mr. S.K. Mohanty. And counsel appears for the appellant / applicant. All right, it will come on 27th. Yes.
Item number 20.
May I please?
Yes.
I pray for only a week's time to remove the defects, my lords. I pray for only for a week's time to remove the defects, my lords. Inadvertently,
you have not also filed the certified copy.
Inadvertently, I have filed the certified copy in the disposed of read petition. Inadvertently, I have filed that.
Not on the certified copy, according to the note that you have not the certified copy of the impugned order.
My lords, that is impugned order.
You have not filed the certified copy. You are also to file a petition for.
My lords, that to remove those defects. I want.
You are Mr. Mahapatra.
My lords.
Mr. A.K. Mahapatra.
V. Mahapatra.
V. Mahapatra, not A.K. Mahapatra.
That's his father.
V. Mahapatra and counsel seeks a short adjournment for removing the defects as identified by the registry. Rest and allowed. Let the matter be listed on 27 September 2023.
27 September.
Have you appeared for?
No,
Normally, I am appearing.
All right. Next.
Item 21.
There is a delay in filing the writ appeal, my lord.
This for the first time before us?
My lord.
Yes. Have you removed the defects?
Yes, defects are.
Supposed to serve copy. Have you served copy?
Already served. Copy already served. My lord, I am having the receipt. Copy served. My lord, receipt number 448099.
If he says he has not received copy, then what will happen to the receipt?
Already served.
Not.
When?
My lord, it has served on.
Who is appearing? Mr.
First
Are you appearing?
Yes, ma'am.
First August.
115 days delay.
Copy, at least he may serve a copy, my lord, so that I can, if 100.
He says he has served the copy.
Then I will verify it from my office.
No, there's 115 days delay. You have objection.
Yes.
Every day you are filing.
I don't have an objection so far limitation is concerned, because in all the cases we have limitation in the state rate appeal.
What is the cause of your delay?
My lord, ill health of the appellant.
Huh?
He was from Fulbani and he was ill. Therefore, I could not prepare the appeal memo and filed it. After
You serve, whether you have an extra copy
My
right
lord,
now.
right now not having an extra copy, I will solve it.
Serve it so that Mr.
My
Kutia, that at least we can do one step forward.
I have no objection for condemnation of bill. Let us serve a copy.
Keep a copy for your record.
All right. IA 4804 of 2023. Heard Mr. R.K. Raut, Clerk Counsel appearing for the appellant applicant. So this is an application for condonation of delay. There is a delay of 115 days in preferring intercourt appeal. Challenging the order dated 28/11/2021, passed by the learned single judge in WPC number 1806 of 2021. Mr. M.K. Khuntia, learned additional government advocate, appearing for the respondents opposite parties, has submitted that those opposite parties will not resist the prayer for condoning the delay.
Well,
so we have also perused the causes assigned for explaining the delay. So having regard to all these regard to the aspects of sufficient explanation, we find that the applicant has made out a case for condonation of delay. Accordingly, delay stand condoned. In the result, this application is allowed and disposed of. He has now appealed.
I have already solved, but still then in course of the day, I am solving a copy. Let it come on Monday, my lord.
The learned single judge says it is a disputed questions of law.
Disputed question of fact, and it was not within the purview of the settlement commissioner to decide that. That is a wrong proposition of my lord has been held, my lord, because the revisional authority has
Today,
to
because
decide.
you have not supplied copy
My
today,
lord.
Mr. Khuntia may not.
My lord,
make.
but I
So
have,
we are fixing some other day.
my lord, and let it be on Monday. I am solving
No,
the
no, no,
copy in
Monday
court.
is not possible.
Next week, any day.
No, no, that's also not possible. Let it be on 12th. How many matters are there on 12th? Oh, 8th. No, 8th, there will be no division bench on 8th. 15. No, don't Friday. Let's avoid Fridays. Twenty-seven September.
Little earlier.
It is in the order passed in 7 such, and the matter will be listed on 27th September for admission.
Oh, like.
Item number 23. May I please your lordships?
Yes.
There are defects there are many defects. I'll remove the defects in the
All right. Let the matter be listed on 18th September.
The similar batch matters has been fixed to 27th September.
27th, all right, 27th September. In the meanwhile, the defects as identified by the registry shall be removed.
Right. Item 24.
If leave is granted in favor of the petitioner to pursue the relief by filing an appropriate application in respect of the relief seeking stringent action against the respondent number 4.
Item 26.
Item number 26, your lordship, counter has not been filed.
2016 matter, here you make your submission. No counter, you are for the petitioner. Make your submission. Why are you urging for the counter? You say the counter has not been filed for the last 7 years, so it should be deemed that they have admitted your abundance. Make your submission.
Lordship, the next week matter.
Make your submission, otherwise I am going to dismiss the writ petition right now.
Next week, Lordship. I pray next week, Lordship.
No, you have to make the submission right now, because you have stated they have not filed the counter affidavit.
But they have.
And
filed.
the 2016 matter, you are not approaching this court by stating what is your grievance. Yes.
Well, I'm sorry. Well, here is a matter, my lord, where the wires of the rules is under challenge. It's a recruitment rule framed under proviso to Article 309 of the Constitution. Entire case is, there is a central statute, namely Motor Vehicles Act, is in vogue. There, my lord, under the Motor Vehicles Act, there are certain provisions with regard to what should be the eligibility of a person who is to be appointed as a motor vehicle inspector. Here, my lord, while framing the rules, the requirement as prescribed under the Motor Vehicle Act, that has not been taken care of. Rather, in derogation of
there is just state clearly whether it is not taken care of or it is in contrast to the central.
It is in contrast. It is in contrast. That is why it is under challenge. But one factum of which I want to humbly bring it to a lordship's notice, virus is under challenge. No counter has so far been filed on behalf of the state. Whatever counter your lordship is seeing on record, that is filed by the recruiting agency. That is Odisha Staff Selection Commission.
No, they have nothing to do with the rules. Forget about it. This is a mere question of.
No, what I am submitting. This is the Transport Department. So Mr. P.K. Behra is appearing.
We are not concerned. Mr. Behra is not available right now in the court.
No, P.K. Behra is their standing counsel.
So what? We sent the vehicle to bring him inside the court.
No, madam. That we cannot.
Purpose of this submission.
I can only say on behalf of Staff Selection Commissions. Opposite part number 3, madam.
They do not have any role in the rule framing.
Yes, madam.
Affairs.
If your lordship will give me one opportunity so that I can appear for the state government.
We'll take up the matter on Monday next, heard in part. Mr. B. Tripathi
and also I will say inform also Mr. Behra also.
Whatever you do, none appears for the state when the matter was taken up.
Transport Department, madam. State Transport.
None appears.
Madam.
I'm saying that nobody is appearing for the
yes, madam.
For the opposite parties when the matter is taken.
Well, can it be on Tuesday?
No.
Tuesday, I'm saying day after. Your lordship is fixing to Monday. I'm praying for
I am
Tuesday.
not granting any accommodation to the petitioner.
Have you served a copy on Mr. Behra?
Yes, my lord. It was served before the.
You come on Monday.
It was served before the state government.
You come on Monday because it is 2000.
No, I have not served. I have not served.
It is a 2016 writ petition.
Serve a copy on Mr. Behra.
It was filed before the tribunal, which has come on.
Whatever way, it is a lease of 2016.
My lord, your lordship is correct.
Come on Monday.
Yes, my lord. Obliged.
Next.
Transport Department, you to serve.
28.
My lord, I would, Mr. Sahu, my lord, is for the petitioner, Mr. Niroj Chandra Sahu, my lord. His face suddenly indisposed, his requested me to take time on his behalf, my lord. It's a PIL, my lord, I am also not very.
19874.
19874.
Malas, there is another connected matter that may be tagged along with this.
What is that matter?
That is 14558. It relates to that same petrol pump, Malas.
Of 2019?
The same opposite party has filed another writ application.
Year of the case, 2019. Year of the case.
Of 23.
Of 23. This is a 2019 matter.
Yes, ma'am.
Anyway, you are appearing for whom?
Opposite party number 5. The selected bidder.
At the request of Ms. S. Patnaik, Learned Council, appearing on instruction of Mr. S. S. Sahu, Learned Council, SS or NK Sahu?
NK Sahu, my lord, NK Sahu, Nirod Kumar Sahu.
NK Sahu. Let the matter be listed on even 11th of September. Can it be?
Any day, your lordship.
Huh?
Any day, your lordship.
11th of September 2020.
Bless. Bless.
Mr. Milan Kanungul and his senior counsel, arrested by Siddharth, who is Siddharth Das, and counsel, appears for the opposite party number 3. You are 3 or 5. His record is 3.
For opposite party number 5, 3.
3. You are appearing for 3.
3 or 5.
Opposite party number 3.
3 months.
Stop.
3.
Mr. Kanungul and his senior counsel has pointed out on the same subject matter, there is another writ petition is pending. Another writ petition being WPC 14558 of 2023 is pending in this court. So, this is directed to place the record of the same writ petition on the next date. Next.
Item number 30. Obliged. Item 30.
Yes. Writ petition by the state.
Yes, I have filed a petition.
Why?
Regarding the drugs disposal matter. Drugs disposal of drugs. In view of the judgment of the Honorable Appeal Court in the Union of India versus Mohanlal.
All right.
During this period, we have destroyed 36 tons. At Ganja. There also there is the table.
Total, there is no amicus in this matter.
I am appearing for the registry.
Okay, then you are the amicus. Have you checked this? Affidavit?
Yesterday evening, I have received the copy. Well, in fact, my lord may kindly see the detailed judgment.
Only the para 2 is relevant.
Paragraph 2. I have also presented in a tabular form. Page 2.
I think the para 2 is the only relevant thing.
2 to 4.
The para 2 relates to what have been destroyed in the meantime.
Now that is what that you have to bring on record. But what about the para 3, Mr. Kotokia?
No, that is plus regarding certification, process certification, where application has been made by the police before the concerned magistrate.
Certification for disposal.
For disposal.
So why have not destroyed those materials?
Because thereafter it will go for the destruction.
Why?
I'm reading that portion.
How much time take this one ton drugs? How much time do you take for destruction?
No, because it is.
You are not taking on into the incinerations.
Well, in fact, a detailed guideline has been issued in this matter by judgment dated 31st January 2022. That is available in record. My lord, can you see? Paragraph 25.
Yes. What is the judgment?
That is judgment dated 31st January 2022 in this matter. And the guidelines have been prescribed at paragraph 25.
Just see any judgment, copy of the judgment is there or not. There is in continuation with Mohanlal.
Yes. Because the state finds some impediments in carrying out the order passed by the Honorable Appeal Court. That's the reason why the writ application has been filed. And guidelines have been prescribed both on the judicial side as well as on the administrative side.
This court, judgment of this court.
Yes, in this matter.
In this matter. Oh, I thought this Supreme Court.
1st January 2022.
May I pass on my copy? Yes.
31st January.
Yes, ma'am.
2022.
2022.
Yes, ma'am.
So 19 pages.
No, it's just for observing the Mohanlal's procedure.
Yes. No, a detailed guideline has.
Additional guidelines are there.
Yes.
Where at what paragraph?
Paragraph 25. Internal page 17 of the judgment. Yes. Yes.
And thereafter also one standard operating procedure has been adopted.
Yes.
So everything is being done under standard
Yes,
operating
yes,
procedure. All right.
Process.
Well, only to expedite the process. So,
And thereafter, after the judgment, plus around 300 tons of ganja has been destroyed from the table your lordship can peruse.
no concern is why the 15 metric tons, 15 tons and 2 quintals and 22 kgs and such ganja is still maintained in the stocks.
No, that is because we have stated like this. That is the certification of correctness has been made by different courts for 15 tons, 2 quintals, 22 kgs.
Why you are not immediately?
Now it will go for destruction. Thereafter, it will go
Throughout
for
the
destruction.
state, not in one court, throughout the state.
All right, but the disposal centers are the destruction also they attached to. They're not brought somewhere, transported to some different destinations. I don't believe
Yes,
so.
yes. There are 3 destinations where it is being destroyed.
Throughout the state.
Yes,
you are bringing the materials from one to other destination.
Yes.
This is completely
That is the reason
costly
why
affair.
it is a very arduous work and that is being carried on by the state police as well as the judiciary. And despite all odds plus, we have destroyed such a huge amount, around 300 tons of money.
Mr. G. Kotopial and counsel appearing for the state opposite parties has submitted that a compliance affidavit has been filed today in court, which has been taken on record. According to the said affidavit, till 23/8/2023, 277 tons, 1 quintal, 33 kgs, and 406 grams of ganja in 1804 cases, and 76 kgs, 125 grams, and 800 mgs of brown sugar in 158 cases as pretrial disposal have been in 128 cases and 94 kgs, 494 grams of poppy straw. It is a poppy straw or poppy straw?
Poppy straw.
Poppy straw in one case have been described as postal disposal. Stop. Mr. Kotokial and councillor submitted that unidentified drugs to the extent of 3 tons, 8 quintals, 65 kgs, and 940 grams of ganja. No, 3 tons, 8 quintals, 65 kgs, and 940 grams of ganja were disposed of as unidentified drugs after receiving those drugs from the district courts of Nayagar, Kalahandi, Kotak, and Bhubaneswar. So, that apart, the authorities have destroyed 798 grams of opium in one case. Stop. As many as 29,719 number of bottles of codeine-based cough syrup have been destroyed in 26 cases. Stop. The table has been formed regarding the disposal, which for better references were reproduced here under. Just as page 2 of the affidavit, there's a table. Huh? Stop. It has been also stated in the said affidavit that that 15 tons, 2 quintals, 22 kgs, and 338 grams of ganja seized in 285 cases, and 1.94 and 126 mg milligrams of brown sugar seized in 23 cases are ready for disposal. As certification of correctness has been issued by the concerned magistrates. Stop. The certification process are also in progress in respect of disposal of 199 tons, 6 quintal, 6 kg, 669 grams of ganja seized in 1,750 cases, and 40 kg, 452 grams, and 210 milligrams of brown sugar seized in 621 cases. So, Mr. Kotukial and its counsel has further apprised this court on the basis of the said affidavit. The certification process is on regarding other seized materials, seized drugs, and the moment the certification will be over, those will be destroyed. Stop. We would direct the Superintendent of Police Special Task Forces within bracket STF, CID, Crime Branch Orissa to immediately destroy the destroy those seized drugs and narcotic substances where certification of correctness is complete within next 3 days. Stop.
A little more or less.
No, it is because of the storage of those materials is not advisable. Stop. The standard operating procedure shall be strictly followed, but there is no complaint that there is any deviation from the standard procedure as of now.
By now,
we'll direct the state of Odisha, direct the authorities in charge of the drug disposals to file a fresh affidavit of compliance. Let the matter be listed on 11th of September 2023.
and last time your lordship expressed your lordship's concern regarding the Malkhan of Bhubaneswar. And there also we have started destroying. That is, I will also get it from page 7.
All right. Stop. We direct the Superintendent of Police Special Task Force to give a detail of the storage of the seized drugs and narcotic substances in various storehouses of the courts after consulting with the concerned magistrate or the district session judge.
Above all, the propelling force will be your lordship's.
Special judge, sorry, huh?
Propelling force will be your lordship's appreciation plus. That works always plus.
That we appreciate it. It is your duty. And we have appreciated, but don't keep the, after certification is over, don't keep the process, just destroy immediately. So up to 30 it is over, no? One matter will take up. After lunch, we will take up only one matter that is fixed at 2. Because today is a reference day.
Okay, only item number 34, my lord.
Huh.
My lord, in the first item, notice has been issued, my lord. But both the my lord, cases arise out of the common judgment, my lord. The second matter has come up today for the admission, my lord. There is one thing, my lord, there is
So first appeal that is admitted.
yes.
Who is appearing for the state in this matter?
I am appearing for the private respondents in that.
No, who is appearing for the state? This is the first case that has been admitted, Mr. Rathod.
Yes, appearing in the 34 items.
So otherwise we admit that appeal also.
Yes.
Fix up any date for hearing.
Yes.
Oh, there is a serious defect, Mr.
But
Ghosh.
there is only delay of 120, 170.
No. You have not filed the certified copy of the impugned order, and also you have not filed any
Yes,
petition.
what I submit, my lord, that certified copy is in the first case, my lord. And
File an application because the rule requires.
I'll do, my lord, or I'll file another certified copy. Let it be done, my lord. Let both the cases come out together. In the meanwhile, I'll do it, my lord.
It is already made together.
Yes, but that only notice has to go in the second matter, my lord.
No, second matter, unless you remove the defect, it's very difficult to issue notice because there is a very serious defect that.
I want to raise something question of maintainability of this application. Let it come some other day.
That comes some other day, 27th of September again.
Yes.
27th, my lord. Of September, my lord. Can't be clearly, my lord.
It's very difficult. There is no space.
Well, I'll just take chance, my lord, lordship chance, my lord, if at all.
1st of September, huh? 21st of September.
My lord, item 30.
Just a minute. Let the matter be listed on 21st of September 2023.
I'm also appearing.
I don't think, Mr. Ghosh, there is any interim order.
There's no interim order.
Mr.
I don't know mention.
Lordship keeping it 21st September. my lord.
Mr. A stars, what you can say, that only, not on the above one, whether you write the name of the.
My lord, I am for the opposite party in item 31.
Yes.
And due to this tear, the opposite party 5 is suffering. It may kindly be taken up. Yeah. Every time it has been time to write.
You are Mr. Das. You are Mr.
I am.
Your name.
I myself for opposite party number 5.
Your name, please, name.
PK Das.
That is why. Mr. P.K. Das, Learned Counsel, appearing for the opposite party number 5, has pointed out that for the interim order passed by this court, the fruit of the impugned judgment cannot be availed by the writ petitioner, within bracket, the opposite party, respondent number 5. Who is appearing for this appeal?
I am for the appellant, my lord.
Mr. S.K. Patnaik. You are Mr. S.K. or P.K.? Mr. P.K. Patnaik, Learned Counsel, appearing for the appellant, has appeared for the appellant. Let the matter be listed on 11th September for disposal on merit. All right. Yes.
Pardon to mention before your lordship, my lord. Item number 32.
32?
Yes, my lord. We listed it another day, my lord.
No, there is a noting that the notice has not been served on the some of the respondents. Have you seen, just see the cause list, there is a noting.
First item, WA number 1781 of 2000.
Just one. Your is 1073 of 2020. Your matter.
1665 of 2023, your lordship.
166.
This petition has been fixed today, your lordship, on the hearing on the maintainability also.
1655 of 2023. You are appearing for 1655 2023. It will go some other day, 21st of September.
Obligation.
List on 21st of September, all the matters. Huh? Yes,
Pray for a free copy in item 30. Item 30.
item 30, free copy, huh? Be given to case Obliged Court of Yes.
May I interim order to
35.
May I permitted to make a mention?
List on 27th of September.
May I
The
permit it,
interim order is passed earlier shall continue till the next date.
Lord, may I permit it to make a mention that item 38, hearing matter.
Yes.
Last occasion, Lordship, here the matter. Lord, a small issue, Lord, the enhancement of age. That my Lordship may fix up any day, Lord, so that it is disposed of.
21st of September
As well, Lordship. Lordship.
is the matter on 21st September 2023 for disposal on merit.
Lordship 32 on 21st September, item 32 on 21st September, my lord kept.
21st September.
21st September.
That's to all items.
The dates will be given, just suggest date, it can be accommodated as per the board. You suggest the date.
Item number 39.
Please, my lords.
My lords. My lords had sought a clarification on the scope of. My lords. Yes, my lords, in ILFS.
Okay.
475.
My lords, I'm appearing in telecommunications.
Okay.
My lords had sought a some submissions on the scope of section 8, my lords. I've prepared a short note, my lords, which has all the provisions which I'll be referring to, so that for ease of convenience. Lords,
Actually, not the scope. Scope is understandable.
yes.
What he says, when the material, suppose we have confronted with two materials. One is the scheme and another is the advertisement and the order. There is the nature of the work has been described, both in the advertisement and the order. That is somewhat different from the scheme. Suppose in the advertisement, in the order, the supply order, there is no reference of the word training is not there. Question is whether court has any duty to explore into the scheme, where
Yes.
on the basis of this usual parlance test, what we call,
yes,
that we can gather some intention of the purpose of the why the supply has been asked for.
Correct.
Then whether should go into the details of the scheme to find out whether the training is a component or not.
Yes.
That is exactly the
Yes,
same
that
issue.
is it. So there are two conclusions which this court must arrive at.
Yes.
The first conclusion is whether or not this is a composite supply in the first instance.
That is
in the first instance, whether this is a composite supply or not.
Yes.
That is what. My lord, may just have the definition of composite supply on this page 1 itself. And then we'll see the ingredients which are of composite supply. My lords, have subsection 30 of section 2. May I read, my lords?
Yes.
Means a supply made by a taxable person to a recipient consisting of two or more taxable supplies of goods or services or both, or in any combination thereof, which are naturally bundled and supplied in conjunction with each other in the ordinary course of business. My lords, I'll pause here for a minute. My lords, these are the three ingredients
which first have to be satisfied to come to a conclusion whether or not this is a composite supply or not.
Then the question of principal supply.
Then the question of principal supply comes that yes, if there is a if it is a composite supply, what is the principal supply which would attract the rate of tax?
Yes.
Correct?
That is understandable. There is no confusion.
So, my lords, what is the, now, my lords, this naturally bundled, these phrases, my lords, have not been elucidated in the CGST Act or the OGST Act. They are identical.
Even I didn't find any judgments also. They have not.
There are no judgments in the Indian context, my lords, which are there. There are no judgments in the Indian context. But, my lords, the CBIC in its wisdom gave out some reading material and information elaborating on what these are. My lord, they are in my note itself. I have reproduced them. My lords may have page 4.
Page 4.
Page 4. Page, my lord, in fact, 3. There are 2 flyers. I have them also with me, my lords. My lords want to have a look. My lords may have page 3. It's the first flyer. It more or less first explains and gives illustrations as to what is a composite supply. May I read, my lords?
Yes, yes.
A composite supply means a supply made by a taxable person to a recipient comprising 2 or more taxable supplies of goods or services or in any combination thereof, which are naturally bundled and supplied in conjunction with each other in the ordinary course of business, one of which is a principal supply. For instance, a travel ticket from Mumbai to Delhi may include service of food being served on board, free insurance, use of airport lounge. In this case, the transport of passenger constitutes the predominant element. Predominant element, my lords, is what is being stated in the principal supply also. Constitutes the predominant element of the composite supply and is treated as the principal supply, and all other supplies are ancillary. A mixed supply means 2 or more individual supplies of goods or services or any combination thereof made in conjunction with each other by a taxable person for a single price, where such supply does not constitute composite supply. So, my lord, either you are if there are 2 or more supplies, either you are a composite supply. If you are not a composite supply, then you are automatically a mixed supply. That is the scope. My lords, we can skip this para. The underlying.
These are understandable.
My lords, what I want to take my lords to is what is the concept of naturally bundled?
Yes.
And what is the factors that are to be considered when my lords have to see whether it is a composite supply, which supply is the principal supply. My lords may again have these illustrations at page 4.
Yes.
My lords, it's the first illustration, which I'm reading in the second paragraph in the italicized portion, where goods are packed and transported with insurance. The supply of goods, packing materials, transport, and insurance is a composite supply, and supply of goods is a principal supply. It is not that the goods cannot be supplied without this, but these are ancillary to it. Therefore, you can better enjoy the supply of goods because there is a hedging of risk with the insurance, transport materials, etc. My lords, the underlying portion, my lords, now is important. In respect of composite supplies, the need to determine the supply as a composite one will arise so as to determine the appropriate classification of such supply as a supply of goods or supply of services, as also the appropriate rate of tax. It will be necessary to determine as to whether a particular supply is naturally bundled in the ordinary course of business and what constitutes principal supply in such composite supplies. Now, my lords, what is the ordinary course of business in this case? What is the perception of the consumer, which is the education department in this case? What is their perception? My lords, this is what is elaborated at page 5. My lords, the foot of the page, the underlined portion. Whether services are bundled in the ordinary course of business would depend upon the normal or frequent practices followed in the area of business to which such services relate. Such normal and frequent practices adopted in a business can be ascertained from several indicators, some of which are listed below. Bullet 1, my lords. The perception of the consumer or the service receiver. If large number of service receivers of such bundle of services reasonably expect such services to be provided as a package, then such package could be treated as naturally bundled in the ordinary course of business. Majority of service providers in a particular area of business provide similar bundle of services. For example, bundle of catering on board and transport by air is a bundle offered by majority of airlines.
Yes.
The nature of the various services in a bundle of services will also help in determining whether the services are bundled in the ordinary course of business. If the nature of services is such that one of the services is the main service and the other services combined with such service are in nature of incidental or ancillary services, which help in better enjoyment of a main service. For example, service of stay in a hotel is often combined with a service of laundering of 3-4 items of clothing free of cost per day. Such service is an ancillary service to the provision of hotel accommodation, and the resultant package would be treated as services naturally bundled in the ordinary course of business. Other illustrative indicators, not determinative, but indicated of bundling of services in ordinary course of business are: there is a single price, or the customer pays the amount no matter how much of the package they actually receive or use. The elements are normally advertised as a package. The different elements are not available separately. The different elements are integral to one overall supply.
Come to the no straight jacket formula, because
there is no straight jacket.
This is a case to case. This is
a completely case to case. My lords, now my lords may just have. I will come to what all in my case makes it a composite supply and what is the principal supply. My lords may just have the decision of card protection plan at page 10 of this note itself. My lords, there are similar provisions in the EU which were deliberated here, and this is the relevant para. I can give my lords the judgments also if my lord wants to go through it. Para 29, my lords, foot of the page. My lord, have it?
Para 29.
Of the foot, my lord, the italicized portion on page 10.
Ah, yes, quoted part.
Quoted part. Apologies.
Yes.
In this respect, taking into account first that it follows from Article 2.1 of the 6th directive that every supply of a service must normally be regarded as a distinct and independent, and second, that a supply which comprises a single service from an economic point of view should not be artificially split so as not to distort the functioning of the VAT system. The essential features of the transaction must be ascertained in order to determine whether the taxable person is supplying the customer being a typical consumer with several distinct principal services or with a single service. There is a single supply in particular in cases where one or more elements are to be regarded as constituting the principal service, whilst one or more elements are to be regarded by contrast as ancillary services which share the tax treatment of the principal service. Now, this is important. A service must be regarded as ancillary to a principal service if it does not constitute for customers an aim in itself, but a means of better enjoying the principal service supplied. Therefore, my lords, we have to see what is the aim of the Department of Education in this case. What is his perception qua this entire arrangement, and whether the perception, the objective is to get a training service for.
Just I put the question differently.
Yes,
the principle that has been laid down is very flexible principle.
My lords.
That suppose I split the tender.
My lords.
I said the one person will provide the goods like computers. Other I engage to provide the training.
My lords.
A split is not unnatural.
It's not unnatural.
Right?
It's
it
not
can be
unnatural.
done.
My lords,
So when those two, one service and one the supply of goods are bundled together, maybe said is a naturally bundled. There will be no difficulty.
Grateful, my lords. I'm grateful.
So what is the purpose? What is the principal object behind it? We are providing these computers, and the computers are to be shown to the students or the teachers. Forget about the consumers of the service.
Yes, yes.
So all right. So whether the supply is the principal supply
Correct.
of the goods is a principal supply, or that you will be appointing someone as a trainer or the teacher as per the agreement, that will be the principal service. When
Great.
these two components comes together, even if we just consider them as a naturally bundled up, what will be the principal supply or the principal component in this bundle services.
My lords had first touched upon whether this split is possible. This split is possible.
Exactly.
There, my lords, the issue of composite mix would not come into question because there were two service providers.
No. No. I think in this case there is no split.
There is no split. There is
so
one,
now in
one,
this, yes. So they have no. Just I have made this first illustration for purpose of showing that there is a distinct characters.
There is, my lords. Let me put it like this.
Exactly.
There is the Department of Education could have purchased these computers outright.
Yes.
Could have engaged someone to provide these services. There is no, they could have done that also. But my lords, the tender documents, the contract, and the communications issued by the Department of Education itself shows a different aim. Therefore, my lords, I had read that card protection plan is what is, my lords have to ascertain what is the aim of the Department of Education in this case.
Exactly.
If the aim of the Department of Education is to promote ICT literacy, that is information communication technology literacy.
For purpose of accessibility, so for the tax is concerned.
My lord, yes.
Whether we should explore all these details or we'll just look at the work order, advertisement, the supply order, which will be the material that will be considered by the assessing authority.
My lords, the material will have to be, my lords, all the documents from which the aim can be asserted. If that is the tender,
why that aim should be ascertained if the aim can be found out from the supply order or the advertisement or the NIT.
My lords, yes, I'm talking about the NIT itself, because the NIT, my lords, makes a reference to the ICT. The NIT says that this is pursuant to the ICT policy. We are all functioning under the aegis of the ICT policy. We have to fulfill the.
I am just the one question is troubling me, Mr. Singh. I am telling you.
My lord, yes.
That what the assessing authority had look at first what document for purpose of assessment of the tax. They should go into do the research work for finding out what is the object or just look into the supply order.
It is, my lord,
that you just broadly address that point.
Let me answer that. GST, like previous indirect tax regimes, is a self-assessment.
Yes.
I will assess myself. I will claim a particular exemption.
Yes.
The department has a right to question my assessment. The burden then shifts upon me to prove why I'm right. It is at that stage where I will put on record everything which is asserted.
In the present case, it is yourself is questioning yourself.
My lords, I have myself
asking for an order on advance.
I said I have gone myself to say that please assess me. My lords, the activity or the actions will remain the same. Whether it was a question of me reassessing my assessment.
Because this is a safe procedure.
Yes. So therefore, my lords, I will have to place on record whatever documents I have to ascertain and to enable them to come to the conclusion that the aim is the training. Then they may find favor with me or may not find favor.
Well, that point you have received well, and don't argue on that point. That according to the object and as declared in the ICT policy, there is a training is the purpose.
My lords.
All right. Now we proceed from that point.
My lords, now my lords may also have this paragraph of in my note only, my lords. What I have done for ease of reference, I have first shown on what all basis this can be considered to be naturally bundled. On what all basis, what is the aim? And I've given with references to the page number of the paper book. That at this particular page of paper book, my lords,
I think nobody will question you that argument that this service and supply of goods are naturally bundled. Because
in fact,
that is where you are asking us to go to the object of the ICT policy.
Correct.
Because you merely supply the goods without training, useless. No
Absolutely.
purpose of over the policy. Again, only training without good doesn't serve any purpose. So those are naturally bundled. There is no problem in that. You can also.
Therefore, my lords, now the question is what is the principal supply?
Yes.
The question is what is the principal supply?
Exactly.
My lords, I'll explain it in my own words. And if my lords wants, I can take my lords to the document, but I'll first explain it in my own words as to what is the entire policy, how this NIT has come about also. Notice the ICT policy was amended and they said that states don't have the wherewithal to upgrade their ICT infrastructure. Nor do they have the wherewithal to keep it maintained, which is a service, to keep it maintained. Therefore, the idea and the aim was to ensure that in the coming millennium, students of all states, be it the remotest of areas, should have access to digital infrastructure. Now, mere access is not enough. because the teachers don't have that capability to teach or train them in using these digital infrastructure. So therefore, my lords, they said that this is, my lords, of utmost
I got your
importance.
point. You say the principal purpose is the training.
My lords, I just want to add one more thing, is that the model is a BOOT model. That is a build, own, operate, transfer. So I will set it up as ILFS, I will own it, I will operate it, and at the end, I will transfer it.
Yes.
So therefore, my lords, the intention here always has been to ensure that a digital infrastructure is set up along with the capability to administer training to students as also teachers in that contract period, so that when this transfer of the digital infrastructure, which has been done over the past 5 years, maintained, trained, once it is handed over to the Department of Education.
Mr. Singh, please conclude within 5 minutes.
My lords.
No, because we have, first of all, I have a single bench and thereafter the reference of by the bar.
I'm aware, my lords. I'm aware.
Yes.
My lords, then my lords may, I'll just quickly take my lords to through my note itself.
Because the Maharashtra advanced schooling that we are already gone through.
Yes, my lords. I'm not going to take my lords to that. But my lords, what now in my case, my lords, in fact, the facts are identical to Maharashtra.
Okay.
The facts are identical to Maharashtra. In fact, Maharashtra makes a reference to the Odisha ICT program also. So, my lords, may just have page 7. I have at various places, my lords, shown giving references as to which will show, my lords, how the aim is the training.
Yes.
So, my lords, the para A9 at page 7, my lords, I speak about the boot model.
Yes.
Then the ICT at all these places says that is to improve the quality of education. It aims at ICT literacy. It provides 3 stages. Then the amended ICT guidelines emphasize the aspect of training at page 299. They emphasize that there is a training aspect. It emphasized greater teacher intervention. The policy, my lord, said that there should be a dedicated teacher that should be there. And I provide that person. I provide that person. The idea of the state, my lords, is not to purchase a depreciated set of digital infrastructure. That is not their idea. Because they have said, my lords, that outright purchase at page 301 is the last resort. Is something that they should resort to if you get no participation from the private sector to do this.
All right.
The preamble of the agreement also says that it is on a boot basis. All these areas, my lords, where I have given instances as to what is the aim. The aim, my lords, because of the boot model, clearly shows that I'm not here to, the state is not here to purchase the assets. And my lords may also see who I am. I am not a Acer. I am not a HP.
I understand. You are not the manufacturer.
I am in the business of integrating technology to provide better education solutions. That is who I am. That is my area of business. My lords, like in competition, under the Competition Act, there is a relevant market. All those principles are seen. Here also, my lords, my area of business is technology solutions to enable students to be digitally literate. That is who I am. And that is, unfortunately, what has been completely misunderstood by the state in their original advanced schooling authority. They say you're a composite supply, but it's artificially bundled. Once you say that it is composite, it is but natural that you're naturally bundled. You cannot say that it is composite but artificial. That at page 98, they make the biggest error. The last thing, my lords, which I would want my lords to see is the intention of the government itself. That is the Odisha government
I
itself.
think we cannot continue after
Your Lordship,
30.
I have already.
I have, my
filed a
lords, I
small
just,
note.
sorry, I just want to show one piece, my lords, just allow me to show just the letter which was issued by the Odisha government at page 339.
339.
My lord, this letter, my lord, I would only implore my lords to have a read at para 2, my lords. My lords have para 2 of 339. It talks about renting computer training to students. My computer training is better enjoyed with the digital infrastructure. They could have purchased it and engaged me to provide that computer training. But they chose the boot model where I build it, own it, operate it, and transfer it to them at zero transfer pricing. If their aim was to own the digital infrastructure and merely to set up these labs, we would not have so many policies.
Yes.
Talking in pages and pages of how we need to increase the literacy.
But if I may take liberty, Malas, to just add what to my learned friend said for 30 seconds, Malas, only, not taking more time. Malas had raised a concern that only the documents with respect to the supply are to be seen to see what is to be supplied. Malas, in addition to all the aims and intention that my friend highlighted, my submission is that the tender documents as well as the agreement.
Mr. Chilani, just let Mr. Singh to conclude his submissions. He has already completed it almost, I think.
My apologies, Malas. I thought he had completed, Malas. That's why I started.
No, he was showing us a document.
Malas, I have page 339, my lords?
Yes.
May I read?
Yes.
Under the e-Vidyala, para 2, my lords. Under the e-Vidyala project under ICT at School scheme, School and Mass Education Department of Orissa through its nodal organization, that is OMSM, under RMSA, by engaging the OKCL as technical consultant to monitor and supervise the project by procuring services from private entities under boot model. Such service providers are responsible for complete end-to-end solution in terms of building the infrastructure, operating the same, for rendering computer training to students, teachers for a specified period, and ultimately transferring the infrastructure to SMAD departments.
Okay.
My lords, this is the letter by OMSM itself. This shows their intention.
Okay.
Rest, my lords, my note has the various
I'll
instances.
just see. Mr. Chilani,
Malas, I will take
only
only
add something.
Malas, only 30 seconds, Malas. I only want to say, Malas, in addition to aim and intention that is to be drawn from the policy, etc. The tender document and the agreement itself are very clear that the object of the government was to receive computer education. Malas, I have submitted a detailed note with the reference to those clauses in the contract and tender, Malas. I would just want Malas to have my petition, Malas, page 141, which is the preface of the tender document itself.
Page 141.
141, Malas. Section 4, Malas, page 141, which is material description of the tender, Malas.
Yes.
Malas, therefore, Malas, provision of computer education is not to be inferred from the intention, Malas. The tender document itself clearly said this is an invitation.
That Mr. Singh also has shown us.
That's correct, Malas. Malas, after that, Malas, there are two more things, Malas, which we see, which is scope of work, Malas, which is at page number 171. 171, Malas, scope of work. Roman 4 school coordinator, Malas. Let's have it. Is 171. Page 171, Malas. Roman
Got it.
heading. It said the school coordinator will be responsible for computer education of students, maintain the hardware, software and accessory at the school, as well as provide assistance to teachers in the use of the IT software, my lords.
You are referring to the clause 4.
Clause 4, my lords, second paragraph of clause 4. And then my lords would see prime roles and responsibilities just under this.
Yes.
Education qualification, training students and if required teachers on IT skills as per as the school syllabus and timetable.
Okay.
My lords, computer education is not something which is outside the contract of the tender, my lords. It is part of the tender itself. The tender is for 5 years. And the 5-year period starts from the day when the installation of computer is complete, my lords. Let's may have the clause with respect to duration of the contract. It makes it absolutely clear. My lords, it's at page 178. Page 178 is duration of the contract. The duration of the contract period for this program will be 5 years. The duration spent for installation of hardware provided by the bidder and software provided by OKCL will not be part of the contract period. And the actual contract period starts after its successful installation in hardware and software and completion of deployment of manpower. Malaks, my humble submission is, it is from the contract itself, it is evident that computer training is the principal objective of this contract. In addition to this, Malaks, my note covers all the other points and the judgments of European Union where
whether the note have been submitted.
Yes, my lord.
With the
Yes,
records.
yes.
Okay, we'll find out. Okay, thank you, Mr. Chilan.
Your Lordship. Your Lordship,
Thank
I
you
have,
so much.
I have submitted a small submission, Your Lordship, on this issue, Your Lordship. Your Lordship, my respectful submission before Your Lordship is that it is a taxing entry of exemption, Your Lordship. So it has to be strictly construed, and Your Lordship, on the last occasion, I have already argued that there is a 3 ingredient, Your Lordship, and he has to fulfill all these 3 ingredients, and Your Lordship, aims and objectives are not be seen in a taxing statute because it has to be strictly interpreted, Your Lordship. Now, Your Lordship, so far as that, I just, Your Lordship has already seen, look into that provision under section 8, Your Lordship. Now, Your Lordship, I just want Your Lordship make one schedule. Schedule 2, Your Lordship, that is one, that good contract, Your Lordship, what my learned friend has stated, that it is a good contract, build, operating, and Your Lordship. Now, Your Lordship, may kindly turn to that schedule 2 in this book. This is a page 213. Your Lordship, I'll go, Your Lordship, the transfer. Got it, Your Lordship?
Yes, I will find it out.
Lordship. Your Lordship, in the schedule 2. Now, Your Lordship, may kindly, I am directly turn to the scope of contract, Your Lordship. How this is not a training program, what Maharashtra advanced ruling has not gone into. Your Lordship, may kindly turn to 5. I just only point out 2 to 3 paragraphs only on this issue. Now, Your Lordship, but paragraph 6, Your Lordship, it is only submitted petition has contended the activities undertaken by it under good model. Therefore, the ownership in the infrastructure developed by it to transfer after expiry of the contract period of 5 years. This is also clearly provided in the agreement that ownership of the entire hardware, software, other equipment will be transferred at 0 value at the end of the period. And what I have already shown, Your Lordship, schedule 2(1)(c)
Yes.
of the GST Act, it is clearly defined that any transfer of title in goods under an agreement which stipulates the property of goods shall pass at a future date upon payment of full consideration as agreed is a supply of goods. How Your Lordship, here the supply of goods is the predominant object, Your Lordship, and the principal supply, Your Lordship. How that is here?
That is your country.
Your Lordship, the scope of contract itself says that. Your Lordship, in addition to the above, the petitioner before the appellate authority also, the appellate authority has put the same question. What Your Lordship has asked, the appellate authority at page 68, the first brief. Your Lordship, may kindly turn for a moment at page 68.
Mr. Mishra,
Your Lordship.
because since Mr. Singh and Mr. Chilana is addressing us from outside,
Your Lordship.
let us continue Monday at 3. You just complete your submission.
Monday, Your Lordship, the 2G matter is there.
Oh, yes.
Monday, your lordship has fixed.
2G matter is at 3.
At 2 o'clock.
No, at 3, I propose that at 3. 2G matters will of course take much time.
Your lordship, I have to argument on that day because I think they
No,
have
because
completed.
we are in a jeopardy now.
Your lordship, that I can understand. On
Tuesday?
Tuesday, your lordship.
Tuesday. You be there on this busy, huh?
Yes, I'll be there.
Your lordship, also in my lord and friend's case, I have filed a submission, but on this issue, I may be permitted an additional submission just on small.
File it.
Your lordship.
File it.
Okay.
But send a copy on the previous day by email.
If it is the local council,
All right.
local council is there.
Right. For continuation of hearing, this matter on Tuesday night. It will be taken up at 3 p.m.
Your lordship.
At 3 p.m.
Get free.
Keep this with records.
Rest admission item number 1, CMAPL 645 of 2020.
In this case, the interim application by the IN number 21 of 2022 has been dismissed for default on 28 August 2022. Due to missing of the list element, I could not attend the petition court. Notice the record to issue.
Several times the matters are listed. What is the order? Have you given the order?
Order 28 August, 28 October 2022, my application has been issued. Non-appearance for the party despite passover, the application is dismissed for non-present.
Yes. This a 2017 matter was dismissed in 22.
Not
because
the 2017 matter. What happened? 2017 matter has been disposed of on 4/1/2019. And since this is an application arising out of issue for appointment of arbitrator, there a settlement was going on between the parties. Both parties approached before this on court. So since the matter is going to be settled, then the Sun Court disposed of the original arbitration petition, granting liberty to the parties to make fresh application if the settlement is not possible for revival of the proceeding. I have filed an
appearing for the opposite parties.
My lord, I have the instruction to appear in this case, my lord. That a copy of the CMPL which they have filed one I.
Please supply.
I will supply.
Next Friday.
Next Friday. All right.
Next Friday, if you have an objection, file right there. List on next Friday.
Well, I have supplied in course.
Meanwhile, the opposite parties will be at liberty to file the objection, if any. But it is made absolutely clear, no further accommodation for purpose of filing the objection will be provided by this court.
Petition have already supplied in court.
All right. I am not mentioning about that thing, yes.
Item number 2.
Item number 2, I had taken notice to the opposite parties. On 11/8/2023,
yes.
my lord was pleased to give another chance, though the notice has served, the tracking report says so. My lord, for the interest of
nobody is
justice,
appearing now.
the notice has been served, my lord. Sufficient.
All right. Heard Mr. D.K. Sahul and counsel appearing for the petitioner. This is an application for the restoration of ARBP number 62 of 2016 on recalling the order dated 23/4/2021, passed in the said ARVP number 62 of 2016. So by the said order dated 23/4/2021, the said ARVP was dismissed for non-prosecution as there was no representation for the petitioner. It has been stated in this petition that due to the ill health of the petitioner, the counsel of the petitioner could not appear before the court on the time when the matter was called out for his ill health. Despite the notice, none appears for the opposite party. As such, we have the view this petition should be allowed. Stop. Accordingly, the order dated such and such, passed in ARB number 62 of 2016, is recalled, and ARBP number 62 of 2018 is the restore please original file. In ARBP number such and such, release the matter on next Friday for hearing. In the meanwhile, the petitioner has sent a fresh notice to the opposite party by speed post to its AD. So steps shall be taken in the course of the day.
Steps by 2-3 days may be taken.
No.
2 days might 5 days.
All right, by
Monday.
Next 2 working days.
Oh,
but you take steps because next Friday I have speak the matter. By speed post you send it.
Speed post, my lord, today, reading now 3 p.m.
Speed post, there is a night counters also, find out. Yes.
To all opposite parties, my lord.
2 working days take within 2
Yes,
working
2.
days. Let us see next
Yes.
date. Yes, next call.
Item 3. Item number 3.
Item number 3, Saurabh Sagarwara. Actually, my lord, because of some inconvenience, I have not prosecuted. Actually, as mentioned in the annexure P1, the cause list has to start at 11 a.m. But the justice
All right,
started
you
at
appear on the
10:30
next
a.m.
Friday. List on next
Sorry?
Friday, the request to the petitioner who has appeared in person. Already come.
Item number 4.
Yes.
Item 4, may I permitted to withdraw, my lord. Matter has been settled.
File it, memorandum.
I'm filing the memo.
He is there already. The petition has filed one memorandum, second leave of this court to withdraw this petition. You are Mr.
S.R. Naik,
Mr. S.R. Naik, and the counsel is appeared for the petitioner. And submitted that petitioner shall be, the petitioner be allowed to withdraw this petition. Where stands allowed? This petition stands disposed as withdrawn.
Item number 5.
And the but I'm relating to dismiss from before matter on prosecution.
Yes. Can a CRLMC be restored?
That is why that I was thinking from the very beginning. But it should not also dismissed in non-prosecution also. That is my humble submission.
That is an illegal order.
That would entirely, my entire contention would be before Lordship.
But whether that
In a
will
criminal
give the
proceeding,
court
ordinarily it should be hard on merit and decide. Even court can consider and decide the matter on merit.
That is,
But can the court dismiss on
there is
non-prosecution?
difficulty because in the CRPC doesn't have this.
That's true. Entirely, I entirely agree with the Lordship. And he has also stated 151 CPC, the council who has drafted, that I'm bowed down. So far the law is concerned, I'm bowed down. But my humble submission is, it is not a case where it should be dismissed in non-prosecution. It will be hard on merit and decide the matter. I
There
can
was an
understand.
application under section 482 CRLMC.
480, yes. It is a 480.
Yes.
Yes, yes.
Better to file a fresh application. There we contest that whether a second application can be filed when the earlier application has been dismissed.
Again, question of law and many things will come.
That only there can be, can be discussed. Otherwise, it's not.
Minimum, liberty minimum law is, again, they will say that.
It is not a 397 petition. Only under section 397, there is a bar.
All right,
482 court can always exercise the inherent.
Once exercised and dismissed.
No, dismissed, I understand.
Or non-prosecution.
For non-prosecution, you said there was no decision from the court.
Let me examine, madam.
That is the only thing.
I can tell agree with the Lordship insofar as criminal proceeding is concerned.
Don't press this application.
All right.
Mr. Suggestions, counsel, huh? Mr. Kotukia, where is he? He is not there. Mr.
I'm there for the state. I'm there for the state.
You are appealing for the state?
Yes, sir.
All right. Mr. KP Minister and Senior Counsel listed by SUBHASIS has appeared for the applicant and submitted that they will not press this application. So accordingly, this application stands dismissed as not pressed. Stop. Mr. Sajensis has appeared for the state. State. All right.
All right.
No, that I will rise, Mr. Kaur. The other matters will go to the next Friday. All the matters will go to the next Friday. Next week also on Friday, fix all these matters on Friday. Next Friday will be single bench on this whole day.
Should we take it up next Friday? Much obliged.